are on the record.
Thank you. Well, for the record, this is a final hearing or a full hearing on an application for a civil stalking protection order filed by Jessica Little and against the respondent Christopher Hicks. The court granted a temporary order last week. It's on for full hearing today. There are a couple of things I just wanted to take up before we get started. I'm told there are a couple of people from the Claremont County Prosecutor's Office here.
Yes, Your Honor.
And what?
May I approach, Your Honor?
You may.
Okay.
You may. And
Your Honor, I'm Brian Schreiber. I'm an assistant prosecutor with
Okay.
the Civil Division of the Claremont County Prosecutor's Office. With me is my colleague, Jason Fountain. We're here to represent our clients who have been subpoenaed to this hearing, so we're just here in that capacity.
Okay.
So if there's anything that needs objection to, we may raise objections
all
on those
right.
issues. But
Okay, fine. Well, welcome to
thank you, Your Honor. Nice to meet you.
Claremont County Court of Common Pleas. Are there any opening remarks on behalf of Ms. Little or Mr. Hicks?
Your Honor, before we begin, I have several motions pending before you that would have an effect on what evidence could be introduced here today.
And I'll take
I'd
those
like to
up.
make sure those are adjudicated before we start any hearing.
I'll take those up right now.
Okay?
Okay, a record will be made of my position on the motions at this time. I've got a motion filed June the 17th, and I think this was the first motion that you filed, Mr. Hicks. And I believe it's premature, although I do believe that after hearing the evidence, the court may well conclude that you're entitled to some relief from some of the restrictions.
Can you read the caption of the motion? Because I filed, I think, 5 or 6 on the same,
Yes, you did.
at the same time.
Motion for change to the written, ex parte, civil stalking protection order in case number 2026 ZVP 834.
Your Honor, may I speak? I believe you've effectively denied that because that would have been done before this hearing.
Well, then, it's denied, but subject to renewal at the close of the case. All right, the next one filed June the 18th. Respondent's motion to dismiss the petition and memorandum in opposition to issuance of a full civil stalking protection order. Again, that's overruled as premature, so it can be renewed at the end of the case. You've got, this is a June 18th filing. Respondent's motion to strike the petition's prayer for removal of published content. That is overruled. Your citation is to Bay versus Rosaware. That case is expressly limited to prospective publication. It's a prior restraint case, and that's overruled. That's part of the evidence in this case. Respondent's motion to limit the petition to incidents alleged in the petition and to require specification of the claimed pattern of conduct. Well, the court intends to hold the plaintiff to the petition, but there is a thumb drive attached which contains emails and videos in addition to the fact in her statement. And given the time constraints in this case, the rest of the relief asked for identification is impracticable given the time constraints. Likewise, with the respondent's motion for a pre-hearing exchange of witness and exhibit lists. That also is overruled as impracticable. And then there's finally plaintiff's motion in limine. The court's of the view that sitting without a jury, the court can hear without, the court can hear the incidents that are allegedly elements of the case that support the claim of a pattern of behavior, and the court can glean from the evidence which ones are and which ones do not count toward establishing that pattern of behavior. Now, I think that's all of your motions. I've got a motion here on behalf of a Mr. Mays.
That was not all of my motions.
Well, you're correct. It's not yours. It's Mr. Mays'
No,
motion.
you said you covered all of my motions and you left one out.
Which one did I leave out?
I believe, since you didn't read the captions, the one that said for immediate revocation or vacating of the ex parte.
I don't know that I... Well, that was the first one I talked about.
No, that was a motion. So there were two motions, Your Honor. One was filed before I had heard the audio of the ex parte to change the restrictions that blocked me from all municipal courtrooms. The second one was after hearing that there was no basis for an ex parte to be issued, which specifically in the statute requires a threat of harm for an ex parte. So that's what that motion was, motion for immediate revocation, vacating of the ex parte protection order.
Well, that motion is overruled. All right. Now, does that conclude your motions?
You did all of mine, yes. I think Mr. Mays has a.
All right. Well, Mr. Mays, under the circumstances, will be excused from appearing today. The motion to quash will not be. The motion to quash will not be granted. In that, I believe that this matter may take more than one day. Okay. Now, is there any opening on behalf of Ms. Little?
Yes, Your Honor.
Your Honor, could we confirm which witnesses are here before we begin, or is that not appropriate? Because I'd like a separation of witnesses.
Well, I think you subpoenaed everybody.
Okay. I don't know who's all here because service had not come back from a lot of places. So if we could just confirm.
Why don't you run through your list of subpoenas, and if the person is here, we will...
Okay. So I know Alex Schaefer's here.
Presence.
Alex Schaefer's here. Ginger Creamer's here. Cheryl Stone is here. Brandon Copley is here. Bob Finan. So Bob Finan, the safety director, is not here. Okay. Hold on, let me just mark this. We know Tom Mays is not here. Patrick McCracken.
Here.
Okay. Tracy Sellers.
She raised her hand.
She's here. Okay. David Little. Oh, okay. Katie Terpstra.
Catherine Terpstra.
Okay. Paul Camphouse, I saw. Scott Solomon. Matthew Brines.
And where's the water?
Okay, that's the list. So what I understand, Your Honor, is Scott Solomon, Matthew Brines, Tom Mays, and Bob Finan are not here. Thank you.
You're welcome. Mr. Croswell.
Thank you, Your Honor. Your Honor, Jessica Little has filed a petition for a protection order in this case. We believe that the evidence will show that the protection order would be appropriately issued by this court. My client will testify that on May 18th, 2012, 26, she received a voicemail from Mr. Hicks in her capacity as a magistrate of the People's Mayor's Court. And in that voicemail, he asked for certain things. She will testify that she did not respond to that because she perceived herself to be a judicial officer and felt that she should not have ex parte communications with either parties or people that purport to represent parties. So she did not respond to the voicemail, but she did at that point note that it was from Mr. Hicks, and she will testify that initially upon that voicemail it caused her emotional distress and concern. She will testify that the reason that it caused her emotional stress and concern is that she was aware of Mr. Hicks's reputation in the community and that she was aware of prior contact that he had had with others. She was aware of the fact that there were those in the community who suggested that he had harassed them and that he had caused them discomfort and emotional stress. The group of people that he had harassed and caused emotional distress is a long list of people here in Claremont County, but interestingly enough, it includes judges, it includes prosecutors, it includes county commissioners, and she felt that if in fact Mr. Hicks could focus on judicially elected people, judicially elected prosecutors, focus on them and be relentless in his pursuit of them and in his criticism of them, that he clearly, now that he was injecting himself in her case, would do the same with her. What he was asking to be was, and notifying her, number one, that he was now the victim advocate of a purported victim in a case, and number two, asking her to transfer the case from People's Mayor's Court to the county court in Brown County. Obviously, it is an ex parte communication. Obviously, a person who purports to be a victim's advocate has no standing to move the court to transfer from one jurisdiction to the next. Mr. Hicks is an experienced litigator, and I would compliment him, as is shown by even the filings that he's made here today. He is an experienced litigator. He's been in court on numerous occasions, and I am confident that he knows that filings in cases should be made through the clerk of courts, not directly to judicial officers. So my client was concerned, knowing that herself, that the appropriate venue to file the request would have been with the clerk of the People's Mayor's Court, was concerned when Mr. Hicks contacted her directly. The next day, her concern and distress even heightened when she received an email from Mr. Hicks asking him to transfer the case to the county court. So not only did he call on the 18th, but when he did not get a response on the 18th, he then pursued her on the 19th. Further, she will indicate to you that she was concerned about this because she now had her second contact from Mr. Hicks, and that she was concerned to what and where it would lead. On May 22nd, 2026, she was in court in Claremont County, in the Claremont County Municipal Court, in her capacity as a court magistrate there. When she looked up, she noticed that Mr. Hicks was now in her courtroom. He had no business there. In other words, he was not a participant, he was not a victim advocate, he was not a witness, he was not a defendant, he was not a plaintiff, he was nothing, he was there, which caused her additional distress and concern because she knew that he had a reputation for pursuing people, filming people, and engaging in discourse on his watchdog website. She tried to avoid him that day and left the bench as her business concluded, but Mr. Hicks approached her bailiff and indicated to her bailiff that he was going to go to her, that since he could not serve her papers, whatever those papers were, whatever he's doing serving a judicial officer, because he could not serve her papers there in her capacity as a magistrate in a completely different court, that he was going to her house. The bailiff relayed that to Ms. Little, and she will tell you that the minute that she heard that Chris Hicks was going to her house, it caused her great concern and alarm, because she was aware of the fact, personally, that he had appeared in numerous officials' homes, and that in fact he had pursued public officials to the point that they were forced to go to the sheriff to get orders notifying him that he was criminally trespassed and that he had to remain off of their property. So she was aware of that. Not only was she aware of that, but she was aware of the fact that he had been in a dispute with her direct boss, Judge Tepstra, and Judge Little, that there had been conflicts between Mr. Hicks and them, to the point that he followed at least one judge, constantly filming them, putting cameras in their face, filming their children, to the point that finally, I believe, there had to be orders to keep him off the property. She was aware of that. In addition, she believed that now that he had escalated his conduct to the point that he would now appear in a separate court for the purpose of confronting her, that this was going to show poorly on the municipal court in Claremont County, to the point that she was so upset she went to the judges and inquired, apologized to them for the fact that he was now there and that she was the focal point of his, whatever it is, his interest. And she indicated to them that she was concerned about her employment. She was concerned that the judges in Claremont County might look up and say that this whole thing that Chris Hicks can bring upon public officials is more trouble than it's worth, and she was concerned they might tell her that her employment was terminated. That's the degree and the amount of distress that she was under even at that point. They will testify, one judge will testify, that she was noticeably distraught in this conversation and after Mr. Hicks appearing in her court. On the 23rd of the next day, on the 23rd of May, Mr. Hicks, on his watchdog site, indicates that the Claremont County court system, and he's entitled to his opinion, by the way, and he's entitled to his First Amendment rights.
Are you talking about May the 26th?
Yes, May of 26. Everything, this all happened in a 2 or 3 week period of time. Everything is what happened here. He indicated in his, on May 23rd of 2026, that the judiciary in Claremont County was imperial and a crony judiciary where party bosses control everything. He went out to point that my client, Miss Little's boss, her judge that she works for, that judge was crazy and displayed paranoid behavior. When Miss,
did this communicate? Was this on his website?
Yes, it is. It's on his what he calls his watchdog website, I believe, is where it was, which he publishes on apparently on at least a weekly basis, not only with his thoughts and views of the world and of politicians in general, but with also lengthy, sometimes videos. But in any event, he published that. On the he then goes on the 26th, May 26th of 2026, he appears in the Peebles Mayor's Court, and apparently there, I suppose, as a victim advocate or whatever he calls himself, and he had been complaining about having the case transferred to county court. Magistrate Little, in fact, transferred the case to county court because she was concerned about her position, about everything that was going on. Well, that didn't suit Mr. Hicks. So after the hearing, Mr. Hicks came up to her as a judicial officer, complaining about the fact that the case, complaining that the case was transferred, and also complaining about the fact that she had not done certain things that he thought she should do, and that she had been was rude by having him wait at this point. As he was leaving the courtroom, he looked at, again, a judicial officer, leaned in toward her and said in an aggressive voice, "There will be ramifications." At which point she took that to be a threat based upon her understanding and knowledge of him and his conduct to that point. On the 28th, on his website, he published a statement calling her a clown. Judicial officer now calls her a clown.
That's May the 28th,
That would be May the 28th, yes.
and you say that is published on the
I believe it's
website?
on the Watchdog website.
Your Honor, I asked for a separation of witnesses. Shouldn't the witnesses be separated?
Well, I'll separate the witnesses. You said I haven't had a motion to do it.
I did it before I went through the list, that I wanted a separation of witness. I stated that.
Well, I will ask anybody subpoenaed to be a witness to leave the courtroom until you're called. But don't go away, just leave the court.
Your Honor, on May 27th,
Go ahead.
okay, on May 27th, Mr. Hicks sent an email to Magistrate Little, a judicial officer, and among other things told her that she owed the participants in this case an apology. And he expected her to apologize to, apparently, the people he was representing or purported to represent, indicated that she should apologize to them. She ignored that. She's tried her best not to engage with him. On May 29th, when she hadn't apologized, he sent her another email. And in that email, he indicated something to the fact, well, it's obvious that you haven't apologized to these people. Because he had continued to contact her and continued to act in what she perceived to be a inappropriate manner, she went to an attorney. And she went to the attorney and explained to him that she was under distress, that she was emotionally impacted by this, and would he please contact Mr. Hicks and indicate that Mr. Hicks should cease and desist. In other words, leave me alone, don't have any contact with me, don't come to my house, don't, and if you don't do this, we're going to have to take legal action. Among the things that this attorney indicated to Mr. Hicks was that he should stay off of the property of Miss Little, Magistrate Little. Mr. Hicks, as he has the right to do, but as he traditionally does, responded to that. And in his response, he said to the other attorney, I'm going to have to check with the sheriff to see if I've been criminally trespassed or if I've been warned by the sheriff not to go there. The clear implication to my client was that if the sheriff had not put him on notice that he could not appear at this property, that he would be back. That was the clear implication, the implication that anyone would draw. She indicates that that was the final straw, and that really put her over the edge, to the point that she became really concerned with her position here. She came to court on the 15th of June and was granted a temporary protection order. One would think that having been granted the temporary protection order, at least for a week between now and the hearing, Mr. Hicks would have, I suppose, for lack of a non-legal term, laid off, left her alone. But she received a phone call and was told, number one, that he, on his website, had directly spoken to her and indicated, Jessica Little, you better, and then gave her instructions And this was, of course, after you indicated that he shouldn't have contact, and so the court can determine whether that's contact or not. But more importantly, as I've indicated, he has a history of being contentious with judges, which causes my client great concern, because her view is if he will argue and fight and abuse judges, she in an inferior position is really in for it. Well, Mr. Hicks, as he's wont to do, on June 21st, this is after you issued the temporary restraining order, but before this hearing on June 24th, he goes to the municipal court of Claremont County.
Now, we're talking about something that happened on June
21st, just 3 days ago, 2026. He goes to the court, he goes to the municipal court, and he has a film where he wants to discuss this entire case. And again, he's entitled to his opinion, and he has the right to say certain things. But he noted at that point that Your Honor was born on March 19th, 1942. Do the math on this guy. He says, of course, they could do the math on me too, Your Honor, but so I'm not making fun of the fact you're 84, because that would cut this way too. But in any event,
Father Time doesn't lose sight of any of us. Does it?
I'll tell you what, there's a lot of things we can control, right? But that's not it. But he does go on to talk about how the visiting approach in the state of Ohio is absolutely asinine and stupid. He then goes on to say that the problem with visiting judges are that they're old and that they don't have the faculties. It's been deemed that they don't have the faculties to be judges. But they continue doing it anyway. So he's an 84-year-old judge here in this case. Well, he then goes on to say that because you granted that order, Judge Wolf, that's how biased it is, that's how corrupt it is, and that's how big an abuse of discretion. Then he goes on to say that this judge, this 84-year-old clown judge, and I'm allowed to say clown, which he is.
Sure.
There he is. It's my constitutional right to call him a clown. So, now, why I bring that up is that when my client then saw that, and saw that not only had literally every judge in this county been under attack by Mr. Hicks, not only every prosecutor, not only the county commissioners, even me at one point, that if he would now, after harassing her, because that's what this really is, after harassing her and causing his discomfort, if he then in the face of all that would turn around and now start on the very judicial officer, the very judge that is going to rule on this case, is going to start on him, it causes her, while she would apologize for his conduct to you if she could, her real concern was not for you. Her concern was, if he'll do this to this judge now, in the middle of this, what have I got coming if I don't have a restraining order? What's it going to be if I don't get a restraining order? She will describe to you the emotional impact that this has had on her. She will describe to you the physical impact it has had on her. She will describe the impact that, frankly, it has had on her husband. And she will ask you to issue an order to give her some peace.
All right. I want to ask you a question.
Yeah, absolutely, Your Honor.
Your interest is in protecting Ms. Little.
Miss Little, absolutely.
Yeah.
Absolutely.
You made reference to Mr. Hicks' briefs. Do you agree with him that he's entitled to some relief with respect to where he may be. Because what I utilized when I granted the temporary restraining order was a form that is provided for the purpose of setting out the relief, but it contained some pretty broad prohibitions on where he could be. And what I'm asking is, do you agree that he's entitled to some relief as to where he may be, putting aside the discomfiture of Miss Little for a moment?
All right. We're not asking you to restrict where Mr. Hicks can go, if that's what you're asking.
That is what I'm asking.
What we are asking you to do, though, is wherever he goes, tell him he has to be 500 feet from Jessica Little. So he can go wherever he wants, whenever he wants, as long as he's not within 500 feet of her.
Well, now, let me ask you this. The courts are open to the public.
Mm-hmm.
She's presiding
Mm-hmm.
in her magistrate's courtroom over on
Right.
Fairmount Municipal.
Yes, sir.
Now, I know that she alleges that he is someone that she doesn't want near her, but is he restricted, in your judgment, from simply sitting in her courtroom and observing?
Your Honor, it is his conduct, repeated conduct over the years, that's placed him in the position for her to ask that he remain 500 feet from her wherever he is. And if that involves him not being able to go to a public place, if she's present, if that involves that, then it's his conduct that's placed him in that position. And so, yeah, so the answer is, as far as I'm concerned, he's entitled to go to municipal court. He's entitled to go any place he wants to go, as long as if my client is there and he sees that she's there, he stay 500 feet from her. And let me say to Your Honor, Mr. Hicks has a history of appearing at places that he has no business other than to be filming people, questioning people, putting microphones in their faces, pursuing them. And so if you would look at me and say, Scott, if he got a speeding ticket and was forced to go into court and she was the magistrate, what should happen? Should he leave? I would say no. If that were the case, if he got a speeding ticket and had a legitimate purpose to be there, probably what she should do in an abundance of caution and say, I'll have someone else come try the case. No, I'm not going to tell him to leave. But I can tell you, I can guarantee you that if you look up and you issue any order other than that he stay 500 feet from her, he will abuse it. He will twist it. He will turn it. He will do anything he can do to work around and go around your order. And so, again, in answer to your question, it's a very fair question. I'm not trying to restrict him from any place. I'm simply trying to restrict his access to 500 feet from my client.
Okay, I understand your position.
Yeah, that's my position. That's my story, and I'm sticking to it. But let me just say this, Your Honor.
Don't say.
Yes, sir. Don't. Well, you don't have to worry about that.
In terms of not being inconsistent.
Let me just make a point. I respect Mr. Hicks's First Amendment right. I respect his right to report on people and have his watchdog report. I mean, that's his business. He may be uncomfortable, but he has a right to appear in courts. He has a right, probably, if the truth were known, to have this guy back here filming this, if the absolute truth were known. He's got those rights, and I respect that. But what he doesn't have the right to do in exercising his First Amendment rights, what he doesn't have the right to do is place people in fear, place people in distress, You know, as far back as you and I were in law school, when they were talking about the First Amendment and the right of free speech, the example that we all heard was, you can't yell fire in a theater.
Unless there's a fire.
Well, if there's a fire, you can yell it, but other than that, you can't. And so what I'm saying to you is that while he has those rights, he does not have those rights. For instance, I have the right of free speech, but I don't have the right to threaten you. It's free speech.
Sure.
But, you know, and let me just say, part of what causes her distress, which you'll hear, and you've already heard it, I suppose, when she testified before, I wasn't here, but part of what causes her distress is Mr. Hicks's well-deserved reputation for being extremely tenacious when he digs in on something. And she has seen the impact it has had on others. And if Mr. Hicks is being placed, just like when he's told that the police call him and say, you're not allowed to go to that person's house anymore. You're not allowed to do this. You're not allowed to do that. He has not been randomly selected for abuse by people. He brings this upon himself.
Well, how do you square this discomfort with the idea that when you're in the public eye, when you're, as she is a judicial officer, you are subject to scrutiny and expected to shoulder some of the treatment that another person would not be expected to shoulder, simply because of our tradition of speech and the freedom to speak?
Well, I can tell you exactly. The fact that a person is a public figure on some level can make them a target to certain people. That's number one. Number two, the fact that she is a public figure, I mean, would I be permitted to, you know, follow you? You're a judge. Would I be permitted to follow you every place you go? Would I, if I were a participant in your court, if I were a defendant in your court, would I be permitted to show up at your children's birthday parties at Chuck E. Cheese and sit there and watch? You know, I mean, there is a limit. You know, and I understand. But what I'm trying, you see, she's not unique. She's one of many in this county and in surrounding counties that have dealt with this very issue. And so I would say to you, the fact that she is a public figure does not mean that she is without protections. Does not mean that if he is going to do things that he knows full well is going to cause her distress, then that's protected. She's protected. It's no different. What do you think? And he's not going to deny any of this because he is Chris, a truthful guy. I mean, he's straight ahead. He'll tell you what he thinks. What do you think the purpose? What do you think the purpose of him going out there to the court on the 21st and filming that thing, calling you a clown, all the corrupt? What do you think the purpose of that was? The purpose of that was not to say this judge is corrupt. The purpose was to say I can do and say anything I want, anytime I want, any place I want, and I know that it's going to put her over the edge, and I frankly don't care. Now that's the reality here, and that's the reality of the situation. And while the questions that you're asking from a logical standpoint, from a traditional fact pattern, I understand exactly where you're coming from. But this is a unique situation. It's a unique case, and is the judiciary without protections? I mean, you're a public figure. Am I allowed to threaten you? You know, can I look up and say, am I allowed to bribe you? Am I allowed to threaten you? Am I allowed to intimidate? No, I'm not allowed to do any of those things. You may be a public figure, but I'm not allowed to do any of those things. And so I would say to you that, frankly, if you want to know the truth, I think that part of what he does, has a level, some degree, of terroristic activity. and I don't mean terroristic activity in the traditional sense, but I'm saying it is a test of wills. He is going to get his way, come hell or high water, regardless of what impact it has on you or me or anybody else. And that's the reality of the situation. And so I'll flip the question to you, with all due respect. Does she have to suffer because she is a judicial officer? Does she have to, this is not the stress of the job. This is not, well, now it comes with the stress of the job. I don't like putting people in jail. I don't like people not go. That's the stress of the job. This is not the stress of the job. That's not what this is about. And I guarantee you, even you as a judge, if a participant, a party participant, showed up at your house to discuss the issues with you, you would be concerned. Or my free advice to you is you should be concerned.
Okay.
Okay.
All right.
Okay.
I think that we ought to hear from
Yes.
Mr. Hicks.
Thank you, Your Honor. I've been elevated to a new level of I'm a terrorist now in this county. So I want to get into my opening, and I would say that pretty much everything that was said there was a self-serving narrative to demonize me. And that's what they need here, because they can't find things that I've actually done. They need you to believe this demonizing narrative of Chris Hicks. He's evil. He's Satan. He's a terrorist. He does things that I've never done. Follow people that are Chuck E. Cheese. Follow them everywhere. I've never done any of this stuff. You'll find in this matter, when you look at it, every contact I had was in a professional capacity relating to a pending case where I was the victim advocate for the victims, and I was consistently not responded to. In fact, the victims, who are not here, were told that they could not have a Marcy's Law advocate. And I tried to get the judge to acknowledge it. By the way, the very top of the Marcy's Law advocate form says you have to inform the court of it. So,
let me ask you a question.
Yes, sir.
You're a victim advocate. Now, in my experience, the victim advocate normally works for the county prosecutor. That's just my experience in other courts. What are you simply kind of a person who holds himself out to be available as a victim advocate, or how does this work for you?
So, Your Honor, I hope you're aware of the constitutional amendment, the Marcy's Law constitutional amendment that created victims' rights in the state of Ohio. One of those rights is for the victim to appoint their own separate advocate. What the victims did was complete, and I was trying to get the magistrate or anybody to acknowledge the receipt of the Supreme Court of Ohio victim advocate forms.
So what you're saying is that the Constitution allows the victim to select his own advocate.
Yes, it's Article 1, Section 10A.
And that's how you have come
Correct.
to this.
And the forms that I was trying to get her to acknowledge were the state-provided victim advocate forms from the Ohio Supreme Court, that at the very top of them says that the people that the victim advocate is required to inform of this is the court and the prosecutor. I'll come back to not the defense counsel, but we'll come back to that as we go. I want to do, you heard a tapestry from Mr. Croswell. He's a very prominent attorney, so I appreciate his prominence within our community, or the community of Southwest Ohio. But I want to do in my opening, I want to tell you a little bit about me that's based on the truth, not a hyped up, I'm a terrorist, Chris Hicks is evil person. So who am I? I'm a journalist, Your Honor. I have a thing called the Watchdog Wire across the platforms on which it resides. It has probably somewhere between 50 and 55,000 followers. It's the highest following in Adams, Brown, and Claremont counties, which are the three counties that I cover within that. I have a pretty big reach across those. In fact, I have something on the order of 5 to 10 times the reach of what's left of what were local newspapers that are the ones that still exist here, are run by Champion Media. So I have a significantly bigger reach. I have a significant impact on events. For example, you might have seen in the news that Chad Essert, the police chief in Bethel, was just indicted on 70 felony counts. Why did that happen? Because I broke that there had been a youth that had been alleges to have been victimized by him, and aired on the Watchdog Wire an interview with the victim that resulted in the chief in Bethel having 70 felony charges that just happened here a couple days in an indictment. It was featured in the media, at least in Southwest Ohio. I don't know if it got up to the Dayton area. So I have a very big, pretty big reach and a pretty big effect on what goes on from a news coverage standpoint. Just this April, because of reporting done by the Watchdog Wire, the sitting prosecutor in Adams County, Aaron Haslam, had to resign because he didn't actually live in Adams County. So I have this whole track record. Back in 2017, 2018, Commissioner David Ubel got kicked off the ballot, later got convicted because of me, because of reporting that I had done. So I want to tell you some of that because it gives you a little flavor of why there's such Chris Hicks is evil. It's not because I've done things wrong. It's because I basically expose things that cause there to be very concerns in the halls of power in Claremont County. One of which was in the municipal court. We'll hear from Katie Terpstra, who got appointed judge in municipal court, who I subpoenaed, and is now the administrative judge. The first seat she applied for appointment was to take the seat of Judge Jesse Kramig. Jesse Kramig, why was there a seat open? Because I caught Jesse Kramig in the park with his assistant in improper activities in summer of 24. This man had been Jesse Kramig's lawyer in summer 23 and said you can do 100 investigations and he's not having an inappropriate relationship with his court staff. I caught him in the park on video with his assistant. He resigned the next day. So there's a lot of animus towards me, not because I follow people to Chuck E. Cheese, okay, but because my reporting is very much on point and I'm very much a stickler on our First Amendment protections, and I appreciate you asking me the question. You know, I have a right. I don't need to have a reason to sit in a courtroom. I can just sit in a courtroom because I want to observe what goes on in the court. If I disrupt the proceeding, there's somebody sitting right there. I have never been charged with a crime, Your Honor. For all the evil that you've heard, I've never been charged with a crime. I may someday. They'd certainly love to charge me with a crime if they could figure out a way to do it. But I've never been charged with a crime. He talked about me probably trying to trick you that I filmed on the 21st at the municipal court. No, I didn't. I filmed across the street at the engineers building because your current order on me would disallow me from being in the parking lot of the municipal court. So I don't know why he said I filmed at the municipal court when anybody that knows this area knows I was on the other side of the road because you could watch the cars going by as I filmed. So there's a lot of misdirection you'll hear here. There's a lot of we don't like Chris Hicks. Chris Hicks is evil. You got to believe all this bigger trumped up stuff that supposedly I do. And that's why I filed motions saying, why don't we make sure we focus on what is she actually alleging that I did? What is she actually alleging that I did? Okay, so I've been regularly targeted by public officials here. You know, you've seen in some of my filings, I have, I think, 3 federal court victories over 1983 violations because a lot of times they come after me. It's routine. They love to come after me and try to figure out a way to get me, and this is the latest thing. Okay, so just in terms of why I was involved in all this, this is a very simple case of political signs getting stolen by a person in Peebles, Ohio, which is in Adams County, about an hour, 20-minute drive from here. And so the advocates, the victims, the 3 victims, asked me to be their victim advocate. We did the constitutional paperwork, turned it in. Okay, it's a mayor's court. You probably have a good idea of how mayor's courts operated. He says file it with the clerk. I have no idea who the clerk is in the mayor's court of Peebles, but got it to their public safety advisor, who then informed, you'll see, that the victims were not allowed to have a Marsy's Law victims advocate. In writing, he said they were not allowed to have a Marsy's Law victims advocate. So completely contrary to the Constitution, completely contrary to the Supreme Court paperwork. And there's a whole series of things. So that's how I got involved in this. So my only involvement, we'll hear that I was involved. Jessica Little described in your ex parte hearing that she had a bad relationship with me. Well, I'll show you a video of us doing a candidate forum together when she was trying to get appointed to municipal court here, and I was supportive of her appointment, of her being appointed over the people that got appointed. So I got so she has this narrative that we had this bad relationship. That's a revisionist narrative, and I'll show you. I mean, all this stuff. I'll go through chapter and verse, all of these things. So on the 22nd Let's get to the 22nd, because you have where she claims I had ex parte communications and so forth, and I'll blow that away. Because things like the Marcy's Law Firm or a Rule 12 form, they don't need to be served to the defense counsel. Me sending you a Rule 12 form when you're the magistrate in People's Mayor's Court is not something. But the things that did go to defense counsel, I actually copied defense counsel on, which is the note on May 19th that they'll talk about. She might not have noticed, but the defense counsel was copied on that note. And then she's up telling you in an ex parte hearing that I had ex parte communications. Okay, so what happened? The kind of nexus of all this stuff is I went to the municipal court in open court on May 22nd. I sat there. I never attempted to talk to her. I don't think we ever made any eye contact. Her bailiff came out I've been trying to get her to acknowledge the Marcy's Law status. I've been trying to get her to acknowledge the Rule 12. I've been trying to get her to address that this Bob Finan guy is sending these notes and showing up at people's houses and telling them they can't have an advocate. I'm trying to get her to address that. Continually, she's ignoring it. Her own testimony to you is she knew there was something going on wrong with Bob Finan. Okay, so I'm just trying to alert her. You got to do something about this guy. What's going on here? So I go to her courtroom on May 22nd, never have any interaction with her, never touch anybody. Her bailiff comes out because they were almost done for the day to pick up any trash that people left out in the pews. I try to give him the paperwork saying, can you get this to her? He tells me he won't do it. I tell him, well, then I'm not going to have any other choice but to take it to her house. Why was the 22nd so important? The hearing was on the 26th. That was a holiday weekend. I waited until the last possible day, Friday afternoon, to try to get acknowledgement that these people were allowed to have a victim's right advocate. Think about that. So that I waited till the absolute last minute. Friday the 22nd, it was a 3-day weekend. The hearing was on the 26th. And so I took it to her house and dropped it off. I wouldn't do the same thing right now if you know what I'm saying. But it was an appropriate way when at any point in time, she or somebody that she worked with, like what would happen here if this would happen, communicate back to me, we acknowledge receipt of your paperwork. They wouldn't do that, which is, by the way, very typical here because a lot of times here, people are trying to get me. They're trying to figure out a way to get Chris Hicks. So you'll notice when she testifies, and she testified to you in the ex parte, she communicated back to Bob Finan to stop communicating with her, but she never communicated with me. She never told me to do that. By the way, I don't think there was anything wrong with my communications. Certainly not the basis of a protection order. So it's also interesting when you think about May 22nd at her house. So I finished, and we'll cover this in great detail, I finished at the court about 1:30 based on looking at timestamps on things. I never went to her house till 3:30. Why? I had 2 calls I had to do in the interim. In that time, did they call Goshen police to trespass me? That's why I asked the question about the sheriff. It's because that would be the normal practice. We'll hear that's what Katie Terpster did when I never even was on her property. Katie Terpster did it just to try to get me in trouble. We'll hear about that. I've never been on the woman's property, ever. Okay? So that's what the sequence around the 22nd. It's kind of interesting in that 2-hour interval, you're so threatened and concerned, but you don't let the authorities know you've been trespassed. You're trespassing somebody. In fact, Your Honor, I don't get told to not be around her until her lawyer's letter to me on June 10th. June 10th. The last communication that ever happened where I was following up on a records request and my request, which I think was highly appropriate, that she apologized to the victims on the 29th. That's the last communication I ever had with a woman. Every communication I had was in her, you said it in the ex parte hearing. When you guys were filling out the order. He keeps contacting her in her professional capacity. Well, the misnomer in that was the last time I had contacted her was on May 29th. I didn't contact her after that at all. I got contacted by her attorney. The point of that, to me, was not, and we'll go through it here, was not to, because of real fear. It was to demand that I take down my content. To demand that I take down my content, and to demand that from then on I never attend a court proceeding of hers. And I appreciated you asking Mr. Croswell about the open courts provision of the Constitution. You know, our country was founded on open courts being a key thing, and our state has that as well. So the videos that I posted, and we can look at them, any of them, okay? I don't know if I have the one from the 21st. Okay, but he mentioned that, so hopefully he brought that because he made a lot of representations. I think they want you, I'm assuming you've never watched any of my videos. And so,
For the record, I haven't seen.
okay, so there's a lot of representations being made about what I said in videos and so forth and what my opinions were. And, some of them he was poking at you to try to get you agitated towards me because that's what they're going to need to do. Is you got to be agitated towards me. I called you a clown. I did this. I probably did call you a clown, by the way, but it's not about the events that would merit a civil stalking protection order. It has to be about this overriding Chris Hicks is evil. And the reason I'm evil isn't because I'm actually evil. A lot of people think I'm great. Because why? Because I've brought down so many crooked politicians. Not as a statement of generality, as a statement of fact. As a statement of fact, I've brought these people down. I want to conclude by just kind of issuing what I think you'll hear in however long this thing takes, is that everything I did was protected activity. Everything. I never contacted the woman one time other than in her professional capacity. I was trying to get simple acknowledgement when being told by Bob Finan in emails that I could be the victim's advocate as per the Ohio Constitution, that the Ohio Constitution applied in Peebles. There's actually, in this whole thing, I was trying to get acknowledgement of a Rule 12 request to record the court. I actually think this is fascinating because you've got a big trifecta of significant constitutional issues in this matter. One is Marcy's Law, which is Ohio Constitution, Article 1, Section 10A. The other one is the open court provision, Article 1, Section 16. And I'm still not sure of his answer when you kept asking. Apparently, I can be in her court, but I have to be 500 feet away.
Well.
Okay. And then the third part, these are the big ones, is First Amendment journalism. I'm still going, but you seem like you wanted to ask me a question. Or
I'll withdraw whatever I
okay.
have to say.
So then there's even a little trifecta in this. I was trying to get her to acknowledge a Rule 12 application under the Rules of Superintendents. I was making a public record request in the communications on the 27th and 29th under 14943. And she's a judicial officer under the Rules of Judicial Conduct, and I appreciate you saying that you need to be ready for scrutiny. I mean, that's what we're founded on. Now, maybe people have gotten, to be honest, and you're older, so I want to say this in a complimentary way. I don't know how to say this. Back in the day, there was more local press. So back 60, 70 years ago, there was a more vibrant local press. Today, there isn't. So many of our judicial officers and politicians aren't used to even having a press ask them questions because they're used to hear, I don't know what it's like in Dayton. They're used to hear that only if it's a big deal, they might see a Channel 9 truck pull up for 2 minutes and then leave. They're not used to being subjected to press scrutiny on their on what we're talking about, let alone their decisions in court, that the press would actually critique decisions judges are making in court. But that's a very foundational principle of our country. That is a very foundational principle of our country. Now, so beyond the protected activity, she's a public official. The matters of her great public importance. She's a public figure. She's the ex-elected prosecutor of Brown County. She's the ex-elected prosecutor of Brown County, and she's currently magistrate in 2 counties. She testified to you, and I think, well, here, let's see if it changes. I never made a threat of harm to her ever. I don't think I've made a threat of harm to anybody ever. Okay? That's not the way I roll. Okay? That's not the way I roll. I consider that disgusting. I'd rather be standing at a podium like this arguing ideas, and I despise people who use even implications of violence. Okay? But she said, when you asked her in the ex parte hearing, has he ever threatened you with any violence or harm? Her answer was no.
That's correct.
So it's not the way I roll. Okay? So, every contact was in a professional capacity, and there were four professional capacities. Trying to get her to acknowledge the Marcy's Law advocate status, something the form says the court must be informed of. Trying to get her to acknowledge a Rule 12 request. Trying to get her to stop Bob Finan's unauthorized practice of law, where he actually showed up. She said that I know it's wrong to show up at people's places. That's ridiculous. I believe in shoe leather journalism, so I'll show up certain places and try to get the story, try to talk to somebody about an issue. What I have an objection to is somebody who's
being perceived, I don't know what his actual role was, but being perceived by the victims as an officer of the court coming to their house to tell them they're not allowed to have Marcy's Law protections. That is absolutely, that should be outrageous. That should be outrageous. Rather than be mad at me, she should have been mad that that happened to a victim. And then the fourth thing was trying to ID, and the first time I mentioned this one, who was the solicitor? Because the victims couldn't figure out who they could consult with, which is also their right under Marcy's Law, because the solicitor, Tom Mays, who's now resigned from Solicitor of Peebles, had recused himself. And I kept asking Bob Finan in emails that she wasn't even copied on, who can they talk to? Who is the solicitor? And would be told I wasn't allowed to know. You will look at the emails and you'll see he keeps referring to an alternate solicitor, but he won't provide the name of who the alternate solicitor is, and the victims are not allowed to consult with him. I actually think I'm doing a fantastic job as a Marcy's Law advocate, because this thing was set up to run through a mayor's court. You know the way things run through mayor's courts.
Well, I don't know how things
Okay. Well, we'll get on a road trip together. So
Are we about finished here?
I think so, Your Honor, but have I taken more time than he took?
I'm not.
So she's already had an hour and a half ex parte hearing, so I want to make sure to get my front end statement in.
What I wanted to ask you, and I'll wait until you conclude your opening, but I did want to ask you about some of your witnesses.
Okay.
But
I'll be glad to. I might have to run back and grab. Okay. She never, so beyond this, she never invoked trespass, but in the normal way people would, and you would think a judicial officer would, which be call the sheriff or call the Goshen police to inform them. And you would think if you thought there was some lunatic terrorist coming to get you, that you would think between the 22nd, when I went to her house to drop off the paperwork, and June 10th, you might have wanted to alert law enforcement that the terrorist is on the run and going to come get me. But she doesn't do that. She didn't even do that when her lawyer sent me a threatening note asking me to remove my content and not attend any of her judicial proceedings. Why? Why, if you were actually threatened, why wouldn't you have notified the local police that you were threatened? Now, he said as a judge,
Judge,
she said she hasn't been.
I didn't interrupt him in his presentation.
But I was talking what the facts would show as opposed to...
No, you said I followed people to Chuck E. Cheese's. You made up a bunch of nonsense that has nothing to do with any facts in this case.
Let's just finish up.
Okay. Okay. I'll try to finish quickly. So she never, so it was 19 days after I took the papers that she sent, if I'm reading the right number, that she then had a lawyer contact me that I should, that I could be arrested. He actually said I could be arrested for trespass. Okay. And then I asked, that's why I asked, did she notify the sheriff or Goshen that I had been trespassed? I wasn't born yesterday. I know the tells. I know the tells when she's having a lawyer contact me with the main focus being that I will take down all of my content. If you stripped out the protected speech, if you strip out me contacting her in her professional capacity as a judicial officer, if you strip out what I was trying to achieve, getting acknowledgement of the Marcy's Law form, there is no there in this case. There is absolutely no there in this case. It would be an unbelievable abuse of protection orders for a public official to try to use. It's an abuse to just try to use them in this way. It's not like I did anything that wasn't directly tied to her professional capacity in a case that was in her court.
Okay. Before we proceed, you've subpoenaed a lot of witnesses.
I still had a few more points, but we can go to the witnesses.
Well,
let me grab my sheet of witnesses.
I don't know that we need to
Okay.
He's
more open.
Apparently, Judge, he's in charge of the courtroom, I guess.
See, this is what I didn't interrupt him in his opening, and he got the time he needed for his opening.
You've subpoenaed quite a few witnesses.
Mm-hmm.
And what I'm wondering, and it would only, I would want Mr. Criswell to be on board with this, rather than I would take it that these are rather brief witnesses.
I believe so.
They're kind of foundational witnesses.
Because of the allowance of her to testify as to things representing them that were hearsay when she was presenting them to you.
Well, it just seems to me that a lot of these witnesses are background witnesses in this Worley case and would simply testify as to certain aspects of that.
If your question to me, Your Honor, is, are there a set of witnesses we get knocked off real quick so that if this thing goes on, that we can get them in and out? The answer to that's yes. I would actually prefer hit all those witnesses earlier, get them done, so that they're excused from this process.
Do you have any objection to that?
Judge, I have no objection to anything that you order, but I would indicate that I may object to the relevance of their testimony.
Well, that's okay. I mean, I think these are background witnesses, mostly leading up to the difficulties that these two folks had with each other. So I was just going to say, why don't we get those witnesses on and off, because they don't want to come back tomorrow, for heaven's sakes, or whenever we resume this.
Your Honor, if I may I approach? Your Honor. Thank you.
You are with the Fairmont County Prosecutor.
Yes, Your Honor. So I represent a number of the witnesses who have been subpoenaed by Mr. Hicks, the municipal court administrator, the municipal clerk of courts, one of the bailiffs, Judge Terpstra. I think that's all of them. And I don't understand what the purpose of their testimony is at all. They have obviously important work to do for the taxpayers of Claremont County.
Well, they do. That's why
So I guess I would ask that we get some indication of what it is they're supposed to be here to do and testify about, and whether they're even necessary at all.
It was in the subpoena precipice for each one of them, and it had a description of what they were going to be asked to testify to.
I think, rather than wrangling over whether they should or they shouldn't, why don't we just hear what they have to say? I think this is all background to this situation that we've got in front of us.
Right, I suspect it's proving things that are completely irrelevant to the case.
So again, this is a prejudicial statement.
I'm not sure that they are. I mean, if they're brief witnesses, I mean, the court will give them the weight they think the court's, but I don't think that these are controversial witnesses.
No, Your Honor, I don't think it's controversial. I think it's just a waste of time.
Well,
Again, this is. See, you have to believe this. Everything I do is a waste of time.
all right, well, look, why don't you, let's
We'll respect these courts.
let's call the witnesses, and so they can get back to the important work they do for Claremont County.
So I don't know the flexibility in the approaches or rules in a courtroom. I'm not an attorney. So would you want to call them and have me question them and then have him cross, since they were my witnesses, when in theory she has to do her case? You understand what I'm saying?
We're taking these witnesses out of order.
Okay, but I'll call them, I'll question them, and then he can cross-examine them.
That would be that would be what I would expect would be the way to do it.
Okay, and I looked at my sheet, and I think that I've covered all of the points that are important for me to cover. So.
Well, I'm sure you have. Okay. Why don't you call your first witness so that we can move this along?
Why don't we call the ones I'll do it in order of quickness. I'll take
whatever.
what I think would be quickest, like a Dave Ramsey death snowball. Paul Camphouse, he's the clerk of court, the municipal court clerk of courts.
Okay, thank you.
Maybe you have better grip than I do. There you go. Thank you. I do.
Your Honor,
Yeah.
this is a set of any exhibits I might refer to. Can I approach and hand them to you? They're all Bates stamped and,
Is that for my benefit?
yeah, for you to see them
Sure.
if I tell somebody to refer to one, and then I have a binder of them for any witness, so they can
All right.
turn to the right page.
All right. Thank you. Yeah, these, yeah, I've seen this. Thank you. What are they going to do? You swear me? I can swear them in, no problem.
if it matters, I'm gonna direct him to Exhibit T. So T is in Tom when he gets in here. And it's the only thing I'm gonna ask him to testify to is Exhibit T.
Could I see a copy of it?
It's in there. It's Bates number 81. Bates stamp number 81.
Chris, do you have a copy for me?
Oh, sorry, I do.
Thank you. Thanks very much. And this is 82, you say?
81. There's a legend at the beginning of that, of all of them, what they are.
Before you take a seat, would you raise your right hand? Will your testimony be the truth, the whole truth, and nothing but the truth? Yes,
So I'm gonna direct you to look at page, it's Bates numbered 81 here. So there's the Bates number, so 81. When we get there. So thank you for being here, Mr. Camphouse. So you are the municipal clerk of courts in Claremont County, is that correct?
That's correct.
Okay. And your court process requires that Rule 12 applications be filed with the clerk of courts, is that correct?
That's correct.
Okay. And I have in the past filed Rule 12 applications with your office, is that correct?
That's correct.
And I have at times filed large batches of them to be able to have an entry for every day, every hearing of a particular judge on a certain day. Is that correct?
I'm aware of this one on page 81. I'm not aware of any others.
Okay, so you don't recall me having done that with Judge Terpstra and with Judge Little, where I filed forms for every day, for every hearing during the day.
If you say you have,
Okay, so I'll ask a question a different way. You have no reason you have no reason to disbelieve if I told you that I've done this multiple times before.
Your Honor, he's leading the witness. He's testifying for the witness. If he's going to call the witness, he should ask the appropriate question.
I'm just trying to move fast, Your Honor, because I just want to clarify. I know I'm asking these questions foundationally because there were representations made in the ex parte about my behavior in filing Rule 12 requests specific to Magistrate Little. So that's why I'm asking these questions. So are you aware of me ever having a Rule 12 application denied in your court?
I'm not aware of that, no.
Okay. Are you aware that on June 14th via fax I filed, I think it was either 43 or 46 Rule 12s to cover the whole docket of Jessica Little for the date of June 16th?
Yes.
Okay. And I didn't put them all in here, but do you recognize at least the first couple of those as the first couple pages of the applications that I filed?
Yes.
Okay. Would you confirm that your court requires that every hearing have a separate Rule 12 application, that you can't, for example, use a blanket form to cover a whole day?
The motion has to be properly captioned with the case number, yes.
So there needs to be a motion with a proper case caption for every individual Rule 12?
Every motion requires that.
Okay. So if a reporter wanted to come in and say, I want to have the liberty to film any hearing within a court for that day, the reporter would be required to file separate Rule 12s for every hearing that day in order to have a properly captioned Rule 12.
That is correct.
Okay? That's all the questions I have.
Thanks for coming in.
May I be excused for that?
Yes.
Yes, you may.
Okay, thank you.
Now, Tracy Sellers would be the next one I would call as the court administrator.
Would you like me to get it?
Yes, sir. Thank you, sir. One of the issues with this courtroom is it's so far from where there's any seating. That it takes a while to go get the person.
Well, it's been a very long time since I've been in the Claremont County Common Pleas Court.
Straight across on the other side of the bench, please.
Before you sit down, I swear you're going to swear your testimony to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you.
I'm going to refer you to Exhibit T.
Is there,
Your Honor, I think filmed.
pardon me? You might be. I mean, there is a camera out there.
Okay.
Your Honor, I would point out that the rules allow witnesses to choose to request not to be recorded, and so if you wish to not be recorded, you may so.
I would like to not be recorded, please.
Okay.
Your Honor,
Oh.
if I may, Garrett Myers, I put in a Rule 12. The Rule 12 motions that are in the Rules of Procedure were changed in 2025. The witness has the opportunity to be heard, but it does not have the opportunity to close the proceeding as of the most recent ruling by the Supreme Court. We're happy to shoot counsel or the respondent or His Honor in this case and not show the witness if that's the case. But given this is a high-profile case and that the Supreme Court no longer allows a blanketed opt-out, we would ask that you make a concession here to show Your Honor, the plaintiff, the defendant, or anybody else if this witness chooses not to be on film.
If I may, Your Honor, in response, the request would be to not record.
Is he like, he just gets to talk whenever?
She's my client.
Yeah. Go ahead. What was your statement?
Her request is to not be videotaped,
Well,
so
that's-
that the camera should either point to the floor or to somewhere else in the courtroom, but not to her.
Yeah, Your Honor, we're fine with that. We're fine
Well,
with
yeah,
fine with not showing her hair.
and that's okay?
Yes,
You're
sir.
you're comfortable with that?
Yes, Your Honor.
Thank you, Your Honor.
All right. All right, well,
And just, I'd like to point out that just by dumb luck, Exhibit V in the packet that's in front of you is the current version of Rule 12. So, and I think what he's probably referring to is there's notes that were put in at different points in time. Okay, by the Supreme Court. All right, so, but we have a resolution to that. So, Ms. Sellers, thank you for being here to testify today.
Would you give us your name for the record?
Yes, sir. Tracy Sellers.
Tracy Sellers, thank you.
And what's your role in the municipal court?
I'm the court administrator.
And you know me?
Yes, sir.
Okay. And have you dealt with me on multiple occasions in the past when I'm filing Rule 12 applications to record?
A number of occasions, yes.
Okay. And it's the policy of the Claremont County Municipal Court that Rule 12 applications need to be individually case captioned and filed with the clerk before they are granted. Is that a
Your
correct?
Honor, I am going to object here. This is duplicative testimony. This is just wasting my client's time.
Well, if you'll just allow
Maybe
her
she'll
to
testify
finish,
differently.
She'll be out of here. Is that your practice? Individual captioning for each request under Rule 12?
It is our practice.
Okay. And you've had experience with me filing large volumes of Rule 12s previously?
Yes.
Okay. And now you know that Exhibit T that I pointed you to, that is a filing that I made by fax on the 14th. Do you recognize that filing? I didn't put all the pages in. I put like the first 3 or 4 pages in.
I recognize this, yes.
Okay. And that one was for hearings in Ms. Little's courtroom on June 16th. Have you been involved with me when I've done similar things to file a bunch of Rule 12s to cover a whole day with a judicial officer in prior occasions?
Yes.
Okay. That's the only questions I have.
Cross.
Nope.
Ma'am, you've indicated that you are the administrator for Claremont County Municipal Court,
I am, yes.
and you are familiar with the ongoings of the court.
Yes, sir.
You're familiar with the judges,
Yes.
and you're familiar with conflicts that have occurred with different public officials in the municipal court and Mr. Hicks,
Yes.
and you're aware of the fact that he repeatedly goes to their homes.
Yes.
You're aware of the fact that that they believe that he has been confrontational and aggressive to them?
Yes.
And do you believe, of your own personal knowledge, that he has caused mental anguish and distress to members of the Claremont County Municipal Court and the staff of the clerk's office?
Yes, sir.
Thank you.
Redirect, Your Honor.
What?
So you just testified under oath that you know that I repeatedly have gone to judges' homes. Can you describe specifically your basis for that knowledge in those repeated events that you're referring to?
I'm aware that you went to Judge Little's home and Judge Terpstra's home. And
If I said to you that I never went to Judge Little's home, would you deny that? That I never went to Judge Little's home.
I believe you went to the entrance of where he resides.
And where does he reside?
I'm unsure of his address at this time.
Would you be aware that he lives down a long private drive of multiple houses, and I was out at the street at the beginning of that private drive in front of a no trespassing sign that I never crossed? Are you aware of that?
I am not aware of that.
Have you seen the video that you're referring to, me going to Judge Little's home? Have you seen the video that is a story on the Watchdog Wire?
I believe I saw part of that, but I don't recall exactly.
Okay, but that's the basis for your testimony, is that you saw a video that showed me going to Judge Little's home?
No, my basis is because I'm just personally aware.
How?
There are conversations that occur, your videos.
Do you have any personal knowledge?
I wasn't there.
Okay, so Your Honor, I would like to then play the report that she's referring to, that is what she's alleging me going repeatedly to judges'
I
homes.
object.
I'm gonna sustain
This is his witness. Okay?
I'm gonna sustain
Right.
that.
He can't impeach his own witness.
Well, I can play the video to confirm what my witness said.
I'm going to sustain the objection.
Okay, so I want to object because this witness has testified falsely under oath. So that you've said that you made a statement under oath that you know that I've personally gone multiple times to judges' homes.
To more than one judge.
So multiple times to more than one judge?
To more than one judge. I'm aware of you going to more than one judge.
So what judges' homes are you aware of me going to? In defining home, what judges' homes are you aware of me going
I
to?
would say in the premises of where they live, Judge Terpstra and Judge Little.
Okay. Is Judge Terpstra's husband a recently former officer of the Republican Party in Claremont
Your
County?
Honor, objection.
I'm not aware.
This is
You're not aware?
No.
Not only is it not relevant, it's improper.
I'm sustaining the objection.
Okay, so you have never, your knowledge of this supposed or alleged on your part, me going multiple times to judges' homes, is based on
Objection.
water cooler conversation, and the claims that you have seen a video of mine that showed me going to a judge's home.
Objection, it's repetitive.
Overruled.
Can you repeat that, please?
Yeah, repeat the.
So your basis for saying I go repeatedly to judges' homes is based on essentially water cooler conversation in the courthouse, and that you saw a video of mine where I was standing down the road from Judge Little's house and in the vicinity of Judge Terpstra's house.
Yeah, I think you were standing at the end of her driveway, yes.
That's your entire basis.
Yes.
Okay, thank you.
Anything else?
Yes. Do you stand on your testimony, ma'am, that you are personally aware of the fact that Mr. Hicks, through his conduct, has caused mental distress to judicial officers in Claremont County and the members of your clerk's office?
Yes.
You stand on that testimony?
Yes, sir.
And it's based not only based upon what he does, but his demeanor when he does it?
Yes.
Okay. You can step down. Thank you.
Judge, am I released or should I stay?
I think you're excused.
Thank you.
So I call Katie Terpstra.
Your Honor, I would ask that Ms. Terpstra not have to be testifying about filings of Rule 12 media requests. We have two uncontroverted testimonies of the way the court does it. I'd like to try to save some semblance of his client's time.
I would encourage you to read the precipice that described what I was going to ask each witness.
Well, let's.
So, Your Honor, there are two videos that I'll want to play relating to Ms. Terpstra. It's Exhibit BB is one of them, and Exhibit Q is another.
Good afternoon. I'm going to raise your right hand. Will your testimony be the truth, the whole truth, and nothing but the truth? So help you God.
It will be.
Thank you, Ms. Terpstra. You are a judge in the Claremont County Municipal Court, correct?
Actually, before we get started, pursuant to Superintendent's Rule 12, I would like not to be recorded.
Your Honor, we will concede to the fact of the previous ruling. If you'd like, we can show.
All right.
I would just note for the record that she is a public official.
Yes,
For the purposes of this, the purposes of the court's time, I'm okay with moving the camera.
All right, well, the record will reflect that she's a public official.
Well, I want to enter an objection that public officials under the current version of Rule 12 cannot be filmed in judicial proceedings. I don't have any problem with that being on the record that I've made that objection, but I think the current manifestation of Rule 12 by the Supreme Court took away the blanket just for these kind of situations where you have a elected official seeking to leverage Rule 12 to not be recorded.
Well, we're going to stay with the previous rule.
And we're fine with that, Your Honor.
All right.
For this purpose.
Okay, so Ms. Terpstra, you're a municipal court judge in Claremont County, Ohio, correct?
Yes, and for the record, I'll state my name. It's Catherine Terpstra. Last name is spelled Terpstra.
Okay, so what we're trying to do is move through perfunctory witnesses quickly, so I apologize for not asking you to spell your name, okay? You and your husband live in the same precinct as I do, Union Township P1P, correct?
Where I live, I don't believe is relevant to this proceeding.
I think it is very relevant because of your husband's involvement in politics.
Your Honor,
I'll sustain the objection. I'll sustain the objection.
So, Your Honor, my reporting has been about both Ms. Terpstra and her husband, who is a political official in the Republican Party. So part of the per se animosity that she has towards me has not to do with any actions relating to her, but has to do with stuff inter-party affairs in Claremont County.
I think this goes far afield of what we're here for, which is basically requests you've made with respect to information in which Ms. Little has an involvement and not the personal life of Judge Terpstra or her husband.
Okay.
Now limit yourself to that or I'm going to excuse the witness.
So then I would like to play a portion of audio Exhibit M, particularly which is the ex parte hearing, which is specifically claims made by Ms. Little relating to Ms. Terpstra. It's 55 minutes and 29 seconds to 56 minutes 02 in the ex parte hearing.
What's the exhibit number?
M, but it's a audio exhibit. It's not a physical document. It's an audio file. So I have to play it.
Your Honor,
Okay.
I've tried to be respectful here and patient. We would move at this point in limine that the court limit the witnesses and the questioning to the issues at hand. The issues at hand are, did Mr. Hicks commit acts that my client will testify to? Number one, did he commit those acts? Number two, did it cause her emotional distress? Those are the issues here. The issues here are not who, what, where, when, or where, what the politics of the county are, what the filings are. The question is, in the final analysis, did he do what she says he did, what she will testify that he did, and did it cause her emotional or mental distress? Those are the issues here. The rest of this stuff, I can tell you, we can go on for weeks here.
I know we could.
Well, and I have, and so please make a ruling that limits the evidence here to the issue of whether a protective order should be.
Well, I think the court does need some background. What exactly, Mr. Hicks, is this video going to depict?
So I'm accommodating the court's request to call these more minor witnesses out of sequence of my case in full. So Your Honor allowed testimony by Jessica Little during the ex parte hearing where she was providing you hearsay information on some of these witnesses. One of them was this witness, and that is in the audio of your ex parte hearing from 5529 to 5602. And I wish to be able to question this witness on if what Jessica Little told you in that ex parte hearing. I'm responding to what Jessica Little said, and I think I have a right to respond to what she said in the ex parte hearing and to ask the people who she claimed said or did certain things whether that's true or not.
Your Honor, what she said or didn't say in the ex parte hearing is no longer relevant. What's relevant and what will be relevant is what she testifies here to today.
I'm going to permit this.
Waiting for the audio to switch over. So this is, I can't get it to line up exactly on 5529, so it's a little bit before that. Let me get my computer out. Hold on. Okay, so this is 5433, so it's a little bit. If I get 30 seconds. Okay, 5503. So it should be 5529 to 5602, but I'm starting a little bit before that.
I didn't apply for it. Judge Terpstra applied for it.
Yeah.
I didn't go for it because I was really busy at the time. I ended up having cervical fusion in my neck, and I had a lot of pain, and it was not a good time. I was thinking to just retire. I had a grandbaby. So I didn't go for it. I wasn't interested. Well, he harassed me of, why aren't you doing that, Judge Terpstra? And he just would say all these terrible things about Judge Terpstra. He does not like her. In fact, Judge Terpstra has him trespassed from her property, and the respondent put, and this comes from Judge Terpstra, he put photos of her children on his platform on the internet. She had to contact Facebook to have them taken down. So he does not like her.
Well, let the record reflect that the bailiff is...
All right, that was it. That was that excerpt. So, is it true that you contacted Facebook or Facebook and YouTube to have a video report of mine removed?
Yes, I have had to on multiple occasions have videos that you have taken of my minor children removed from social media platforms where you've posted images of my minor children in derogatory fashions towards me.
Was one of those instances the result of a report I did from the county fair?
I don't know what you're talking about. Can you be more specific?
Well, then I'll play the report for you. So I want to play a report that has your kids in it that is from the county fair, which is...
I would prefer that no videos of my children be entered into evidence and become part of the public record, as it has been a repeated issue of you making my children...
Well, so I can't defend myself at all. It's just whatever you say is true.
Your Honor, first of all, he puts a witness on. He elicits information from her. Then he wants to complain that she testifies, wants to cross-examine her, and have the testimony stricken. Now, it's his witness. He put her on the stand. She's testified, is in the process of testifying about what she perceived his conduct to be, which was harassment, which even from her demeanor here today lets you know that it's caused her emotional and mental distress. He then wants to argue, what he wants to argue is whether it should have caused her distress.
No.
He wants to argue whether he had the right to do these things. And this is his witness, regardless of when this witness was put on the stand, it's his witness. And it is this presentation that he's trying to do here today is emblematic of everything he does out here. And that's where we are.
So Your Honor, I am just trying to show an example of a report. They're making all these wild claims about me and the reports, and I put her kids online, all this kind of stuff. I think the court should see an actual report that is probably the only one I could think of that ever got taken down because of you relating to Facebook. But I think it's important so the court can determine the veracity of the claims and the response of an elected official to being asked questions.
I think it's too far afield. I'm going to sustain the objection.
So I'm not allowed to in any way impeach her testimony that I put her kids' pictures online, which I categorically deny.
This is your witness. I thought you said that this witness was a background witness for events leading up to this.
No, it's a witness associated to her testimony. And I'm trying to get on the record.
She has not testified yet.
She did in the ex parte. She had an hour and 20 minutes where she laid out, I just played part of it. I don't know whether you call that testimony or long-ass introduction.
The objection is sustained.
So the point is, anything that's said about me here that has absolutely nothing. Remember, I asked Your Honor in a motion to disallow any testimony that didn't relate to the specific pattern of conduct in these things. Now we can have her and people make representations, and I'm not allowed to even respond to that.
The court's ruled.
Okay, good. All right.
You made your record. Now, ask her the questions that relate to this case.
The point relating to this case,
No.
what I'm confused.
We're not going to re-argue.
So, but what I'm confused by is the ex parte hearing had myriad things unrelated to this case. He's constantly talking about things totally unrelated to this case. We just had the Tracy Sellers talk about things totally unrelated to this case. But it seems that I'm not allowed to impugn or respond to those things. Is that what I'm to understand?
What did you call this witness for?
Because she made claims to affect you in granting the ex parte that I had put pictures of this woman's kids online in an evil, mean, hateful way. That is utterly and completely false, Your Honor. And I can play the video to prove it.
The court has ruled. Move on.
Okay. When you first sought appointment to the court, the seat that you were trying to get had been vacated by Jesse Kramer, correct?
Objection, Your Honor.
I'll sustain that.
Okay. So I have no further questions because it appears that anything can go for what they can make claims about, but I can't respond to things that were said in the ex parte hearing that you listened to and accepted.
The court's ruled. Anything?
Yes, Your Honor. Judge, good afternoon.
Good afternoon.
It's unusual to reach in this setting, but
Stranger things have happened.
it is. Well, I don't know. I would be surprised. Judge, you've had an opportunity to, you are aware of the fact as a judge in the municipal court that there is interaction with Mr. Hicks and with Magistrate Little, that there's been interaction over the past month or so. You're aware of that, are you not?
I am aware of that.
And you're aware that Mr. Hicks came to your court made a public records request and came to your court for the purpose of observing Magistrate Little?
I know he's been to our court multiple times. He makes constant public record requests.
But this is not even true.
He, specifically, I think, related to Magistrate Little, there was an incident at the end of May. It was the Friday before Memorial Day weekend is probably the most pressing incident that comes to my mind.
And you had an opportunity, did you not, to meet with her and discuss her concerns about what was happening?
I did, following her interaction with him or him being in her courtroom that morning.
And was she visibly distraught?
Extremely, yes, very, very much so. To the point that I made comments to other employees, other judges, that I was concerned that she was so distraught that we were going to lose her as an employee, that she would quit because he had caused her such distress.
And did she indicate in that conversation with you that one of her concerns was that she would either be terminated from municipal court or have to leave municipal court because of the conflicts that he would cause as a result of her being there?
I don't recall her exact words. I do remember that the effect of some of her concerns were what am I bringing to this court by this man now coming here and trying to harass me for this incident, for another judicial role I have where she works for a mayor's court in my primary employment, which is for the Claremont County Municipal Court. So we had a conversation. I assured her that Mr. Hicks's actions are not her fault, but she remained throughout our conversations extremely distressed, and I would say for days, maybe even weeks following the incident, remained upset, and that's not how she usually is. I would say, having had the opportunity to work with her, she is usually a very pleasant, happy, easygoing person, and it was a complete 180 once this began happening to her.
I apologize for having to get into this, but you've had your interaction with Mr. Hicks also, have you not?
Multiple.
Yeah. And during that interaction, has his contact with you...
Objection. So again, we get to, what happened in the ex parte? He's trying to get introduced testimony.
Let's hear the question.
Yeah. That's usually how it goes. My question to you is that you have had your interactions with Mr. Hicks. Is that correct?
Yes.
And they've involved you and your husband and your children. Is that correct?
Yes.
In relation to your capacity as a judge in this county?
In my relation as the capacity as a judge, in his attacks against my husband, and even prior to that, in his attacks against my former employer. And I think the very first interaction we had is he falsely claimed that while I was working as a prosecutor that I was engaged in some type of grand cover-up scheme, but that was probably almost a decade ago.
Yeah, well, if nothing, he's persistent. Would you agree with that?
I would.
Now, my question to you is...
Objection. What does any of this have to do with whether I committed menacing by stalking to her? It's outside the boundary of this notion. It's the demonization questions. Whereas I would be glad to go down these paths if I can play the videos to refute what's being said from the stand.
Apparently, Judge, he's running this courtroom. Now he's telling you what he's willing to do. But the question is relevant because it is, first of all, he's the one who put this witness up. I'm entitled to cross-examine her, number one. Number two, she has information on cross-examination which she's indicated that my client, Magistrate Little, was obviously distraught as a result of the conduct of Mr. Hicks. In addition to that, she will testify, if given an opportunity, that he has caused her emotional and mental distress as a result of his conduct, and that she relayed that to all members of the court, including my client, and that my client was fully aware of what Judge Tepster had been through and the other judges had been through when he turned on them. And that's relevant because it impacts her state of mind, it impacts her reactions to Mr. Hicks, and impacts her mental state in reaction to these things.
I'm going to sustain the objection. I think that we're getting farther afield than we need to resolve this case.
Very well. Very well. Then I'll go directly. But did you have a conversation with my client concerning your mental health and reactions to Mr. Hicks? Did you explain to her what they were?
Sustain.
Very well.
I have a quick redirect. And I'd like to direct you to Exhibit S.
Is that this binder?
Yes. It's on Bates stamp page 76.
You say F?
S. It's Bates stamp 76. Page
S
76.
on
76.
Thank you.
And it's S.
Thank you.
Let me know when you found that.
Okay, yes.
So you just testified that you met with Miss Little, is that correct?
Which date are you referring to?
You met with her after my May 22nd appearance in her court.
Yes, I met with her that day.
That same day?
Yes.
Okay. Did you encourage her during that meeting to call the police or take any particular action?
Objection, not relevant.
She's not her counsel.
I'm going to overrule it. You may answer that.
I did not direct her to any particular action. I just offered her encouragement that we judges had all been through this, that you harassed
Okay.
all the judges, all the elected officials, many of the employees of
Okay,
the
we get it.
courts.
You think I've harassed you.
If I could finish my answer, sir.
I think you have answered. Now you're
Judge,
adding editorial.
but He asked questions that.
My
that are
question
being-
was, did you
Mr.
give her any
Pardon
advice?
me.
The answer is no.
Pardon me.
One at a time.
He asked questions which themselves suppose certain facts which are not necessarily true. When his witness refuses to agree with him and wants to expand on her answer, he objects. He's happy when he likes the answer. He's unhappy when he doesn't like the answer. What she has to say is relevant because it sets the entire atmosphere of this case and the entire atmosphere of Mr. Hicks's conduct with these people. The realities are these. While he may be entitled, as I've said, he may be entitled to have First Amendment privileges, he's not entitled to conduct himself, even as he speaks, in a way that causes emotional distress, not just to my client, but to literally every elected official in this county.
See, this is not in evidence.
Let me hear the question again. Let's just one at a time.
My only question, Your Honor, was, did you give her any advice such as to call the police or anything? Her answer was no, and then she went into a freewheeling editorial about how I harassed every elected official in Cuyahoga County.
His question was, did you give her any advice? And she's answering that question. Did you give her any advice? And he doesn't like the fact that her advice
That's not
was
advice. It's your...
Again, one at a time. The question, you can answer that yes or no, if you know what the question was.
Well, to clarify, because if
Just
you need
ask
it,
your
if you
question.
need it.
Did you give her any advice of an action such as to call the police?
I gave her advice, given the background of your constant harassment of elected officials, that she needed to do what she needed to do to make sure she felt safe. I did not direct her specifically to call X, Y, and Z person to take X, Y, and Z legal action, but we discussed the fact that your constant harassment of people...
Hold on, stop. That's not...
wait a minute.
This is beyond my question. This is beyond my question.
He can't object to the testimony of his own client or his own witness.
Her testimony is that she didn't give her any specific advice except to do what she had to do. Now let's...
Okay. So direct your attention to Exhibit S. Have you seen Exhibit S before? Page Bates stamp 76.
I have eventually, not the date that it was sent.
Okay, so you're aware that I delivered this letter to the clerk and to the administrator and got receipts for having delivered it to them on June 12th, 2026?
I was out of the office that day.
But you're aware that I delivered it that day?
I don't know what day you delivered it, but that's what date it says on there.
Okay. Did you ever respond? It's currently what, June 24th. Have you ever responded to this?
I do not respond to random letters sent to me.
Do you think this is a random letter? You just said that there was an incident in her courtroom. You talked to her. I was involved in the incident. Then she had contacted me telling me effectively I wasn't allowed to be in the room of any judicial, on the first bullet, Part 3, Section 1, any other judicial matter over which she presides or has presided, and I was asking you if this, in your role as the administrative judge, constituted that I was banned from Jessica Little's courtroom.
So
Did you respond to this? That's my question. Did you ever respond to this to me?
I did not.
Why not?
Because it would be inappropriate for me to respond to random letters sent to the courthouse, particularly letters asking me for a legal opinion. I am not your lawyer. I cannot give you legal advice.
You are the administrative judge of the municipal court, correct?
I am.
Okay. So if a judge within the court informed a citizen that they were not allowed to attend their court, that would be a matter that would be proper to raise to the level of attention of the administrative judge. Would you not agree?
I don't understand your question.
If a citizen were told by one of the judges in the court of which you're the administrative judge that the citizen was not allowed to be in their courtroom, that the citizen then bringing it to the attention of the administrative judge as a problem would be an appropriate course of action for the citizen.
I can't answer that in every case. There are certain situations where maybe yes, that would be appropriate. There are certain situations where maybe no, that would not be appropriate. But I did not think, based on your letter, that it was appropriate for me to respond.
Did you consider that I was banned from her court?
Objection.
She objected.
You may answer.
Did I consider you banned? I honestly haven't put any thought into it because I am not the one who can give you legal advice.
So, but you could tell a citizen whether they were allowed to be in the courthouse, couldn't you?
Can I tell citizens whether or not they can be in the courthouse?
Yes.
I think it would depend on the circumstances.
Okay, so you never responded to this letter. Did you have any discussion with Jessica Little about this letter?
No, I did not.
So did you ask her, this letter included behind it, I'll just call the court's attention to, the
What are you?
so page 77, I need to be able to finish, 77, 78, 79, that was the communication I received from a lawyer representing that he represented Miss Little that was attached to the letter. Did you review that?
No, I did not.
Okay. Did you discuss that with Miss Little?
I did not.
Are you aware of any other judge in Clamor County Municipal Court sending a communication to a citizen, part of which is that they're not allowed to attend their court proceedings?
Any other judge?
Yes.
Not
Judge or magistrate.
Just to
Are you
clarify-
aware, let me
Hold on,
re-ask the
hold on,
question.
Let me clarify to make sure I understand. You're asking me whether any judge has ever communicated with a participant in a proceeding that they can't attend their own court proceedings?
No, that's not even remotely what I asked.
Okay.
I asked, are you aware of a judge or magistrate in the municipal court, because I corrected myself, ever having communicated to a citizen that they were not permitted to attend open court?
I don't know whether that's happened or not.
So the answer is, you're not aware, so the answer would be no.
I don't know if that's happened or not.
So the answer would be no. You're not, I asked, are you aware? So the answer would be no, you're not aware.
I do not
It's
know.
not a
if
hard-
that's happened or not.
He is arguing with
Okay, so you as administrative judge, when you became aware through my communication that a judge had sent communication
Your Honor,
to
I
a
object to the
citizen,
relevance and the
I'm in the middle of a
materiality.
question.
Let him finish.
You did you consult with the prosecutor's office?
I didn't consult with anyone about this letter.
Wouldn't you figure that's something that could be a constitutional issue of open courts in Ohio to be an important issue as an administrative judge to address?
I reviewed your letter.
I'm going to sustain that.
Okay, I think that's the, hold on one second, I just need to look here. Have you met Jessica Little? Did you meet with Jessica Little in any way, shape, or form relating to any of these matters subsequent to her filing of a protection order?
I wouldn't call it met with her. I have seen her in our shared work building recently since she has filed, I would say subsequent to her filing the civil protection order, again offering her comfort because she was so distressed, tearful, so worried about Mr. Hicks's repeated...
This is after the filing of the protection order?
Correct. Your
Okay.
repeated attacks on her, both online, that has caused her...
I just asked if you had a discussion.
Yes, this is the...
That's all I asked. I didn't ask for editorial about me. So the answer is, I asked, have you had any discussions with her about these matters since she filed a protection order? It sounds like the answer to that question is yes.
Yes, in the context that I, again, was offering her support. She was very upset that once, in retaliation to her filing the civil protection order, you again posted images of my children online. She was very tearful.
Okay,
very
so the
upset
answer is
that
yes.
you have
Your Honor, if I could get her to
come
answer the
against
question I
me
asked.
in my own personal capacity just for being her employer. So I offered her comfort. Again, I explained to her that it's not her fault, the things that you do, but I believe you to be very mentally ill, and that it's your mental illness causing you to do this.
Okay, so you just testified under oath that you believe me to be mentally ill. What's your basis for that? What's your basis?
My personal observations of you over the
Are you a
many
doctor?
years, I have an undergraduate degree in psychology.
Okay, so you believe me to be mentally ill. So what you're, so do you believe that clouds your judgment about me and everything that you do, like not responding when a citizen alerts you that they've been told they're banned from open court, a constitutional right in Ohio?
I don't believe it clouds my judgment because I cannot give legal advice to anyone, including you.
So if there were a citizen in the courthouse blocking other people from attending court, you would say you don't give legal advice if somebody came to you and said, hey, you should...
Your Honor, I'm going to object on behalf of my client. If this is bad...
He can't object.
This is on rebuttal. None of this was covered in the cross-examination. This is simply badgering of my client.
She's doing fine, Judge. I had no objection.
Well,
She's doing just
I
fine.
think your question's far afield.
Well, but I think her I think my question is not far afield. Given the continual demonization of me, and given your honor that I've just gotten her to say on the record under oath that she believes that I am severely mentally
All right,
ill.
The question is, does that color your approach to me, right?
I think it colors her approach and her claims. So I have my final question on rebuttal is, during all these meetings that you said you had a subsequent meeting with her when she did this, did you ever question to her the implications on the First Amendment, open court, or Marcy's Law of any of this?
I would not characterize them as meetings. I would characterize them as me having discussions with her, comforting her because of her extreme distress over your behaviors. So no, it was more of a comforting aspect as opposed to any type of legal discussion.
Okay.
Okay, thank you.
Fair enough. All right. You still at it?
I am still at it, Your Honor. Mr. Hicks raises interesting issues. Mr. Hicks wanted to debate with you whether you felt that he was mentally ill.
Mm-hmm.
You've had an opportunity to talk, or perhaps has a personality disorder.
Mm-hmm.
You've had an opportunity.
Objection. Now he's adding other things she didn't even say.
Oh, just relax, Chris.
Go ahead. Go ahead.
Just relax. So, you've had an opportunity within the community, the wide community, Claremont County community, to discuss Mr. Hicks,
Yes,
to discuss his conduct,
correct,
to discuss his demeanor.
correct.
Based upon your conversations with numerous members of the community, do you have an opinion as to whether...
Objection. This has nothing to do with whether I did civil stalking with her.
Mr. Hicks, I'm overruling
It's
your
got
objection.
plenty to do with it, pal. Do you, based upon your conversations with members of the community who have interacted with Mr. Hicks, based upon your personal observations, do you have an opinion as to whether there is a feeling within the community that Mr. Hicks is either mentally ill or has a personality disorder? Do you have an opinion?
I do have it.
And what is that opinion?
My opinion is, and to clarify, personality disorders are considered mental illnesses. Specifically, my personal belief, based on my years of interactions with him, my observations of him, my conversations with others who have observations and conversations with him, that he is mentally ill, specifically suffering from a personality disorder. In my own personal opinion, probably a cluster B personality disorder.
Now, you had an opportunity to discuss this and hear discussions and opinions of others in the community.
Yes.
Is your opinion consistent with the opinions held by others in the community that you've talked to concerning this issue?
I would say his reputation and my opinion of his reputation and those of others that I have talked to, it falls one of two ways. They either believe that he is severely mentally ill and that drives his actions, or that he is just an individual who enjoys making other people suffer, lying, manipulating, intimidating, harassing, that's just how he enjoys things. I personally view it as a mental illness, but I know that there are others who view it as that is his personality type and what he enjoys.
Given his reputation in the community and the belief, perhaps, that he is mentally ill, does that impact your interactions with him and your concern when you are having interactions with him?
I would say yes, because as I have been aware of him, have known him, have had conversations with him for years, that it seems that he is increasing in his intimidating, harassing behaviors in recent years, that he is ramping up his aggressiveness, his intimidation, and it is very concerning that he's towing the line, he's crossed the line. How far is he willing to cross that line? And again, that is very prevalent in people with personality disorders.
And is that view, to your knowledge, held by many in the community?
It is.
I have a redirect now.
Are you finished?
I'm not finished. Not yet.
Well, I'm going to object to this whole line of testimony of this nonsensical, that I have some cluster B personality disorder, on and on and on, that has absolutely nothing to do with the purpose of a protection order, and is absolutely ridiculous, and is rooted a lot more in the fact that I've caused several elected officials, including municipal court judge Jesse Kramig, to have to leave office. So I object to this continued line of questioning.
Judge, as a matter of rule of court, would I be allowed to mark Mr. Hicks as an exhibit?
No.
Okay,
I think you're finished, right?
I am finished, yes, sir, thank you.
All right.
Since you're the mental health expert, could you explain what a cluster B personality is?
Absolutely. Cluster B refers to about approximately 4 different personality disorders types, including narcissistic personality disorder, antisocial personality disorder, histrionic personality disorder, as well as borderline personality disorder.
And which one of those am I?
Antisocial would be my opinion, but
Antisocial.
probably a little bit of histrionic and narcissistic.
Okay. If, let's say that somebody did have those conditions, does that impair their constitutional right to appear in open court? Does that impair their First Amendment rights? Does that impair their Marsy's Law rights?
I can't answer a hypothetical because...
You're a judge. You should know the answer to that question.
I can't answer a hypothetical because there could be situations where, yes, that could impair their rights.
Okay. So you're saying yes, that if you, do you frequently make judgments on people relating to their mental health?
I am constantly faced as a judge and as a former prosecutor with dealing with individuals with mental health concerns.
Have you and I ever had a one-on-one conversation lasting more than 3 minutes?
Yes, when you harassed me at the fair, that conversation probably lasted approximately 5 minutes, where I was asking you to leave and leave me alone, and you refused to.
So, Your Honor, I would like to play the video that she just referred to of her and my interactions at the fair. She just cited that example.
Well, this is your witness, and
Well, I would be allowed to play a video that she just referred to, so I'm going to ask the court to allow me to play the video. This is the video that they're trying to block before because it might refute the story that they've told you.
Judge, number one, it's his witness. Number two, he's trying to impeach his witness.
I can play a video for the witness, and then she can recount what she saw in the video to help support her testimony.
In addition to that, Your Honor, she has indicated what her opinion is. She has not indicated that she's made a medical diagnosis. She's indicated what the opinion of others in the community are, what the strongly held opinion is. She's not suggested that any of them have done a medical evaluation of Mr. Hicks. But the fact that people think that that's what he's all about and thinks that he has a mental health issue or a personality disorder plays into the very issue in this case, that the minute he turned his guns on Magistrate Little, she panicked and was extremely distraught because of the very type of conduct that you're seeing here in this courtroom today.
I want to play the video that she just referred to of her claim that I harassed her at the fair that showed that I had cluster B personality disorder or something like that.
go ahead.
Okay.
Huh? What?
Your Honor, if I may ask that the camera not be placed on the video, and that if this exhibit is released, that the children's faces be blurred.
Okay.
Your Honor, we'll respect that.
All right. What exhibit is this, by the way?
I think it is. Hold on. That's what I was getting myself confused. I think it is Exhibit Q.
Q?
Q, yes. The interaction at the fair. This is the report.
All right, thank you as always, Nathan. I know we don't see eye to eye on a lot of things, but you're always a gentleman. Thank you. I've known you for 8 years. Thank you. I appreciate it. I just want to ask her how her judgeship is treating her so
I have no
far.
comment for you now or ever. You can stop harassing my family now.
I'm not harassing in any way, and you're a lawyer, and you know I'm not harassing by asking you a
We're just trying
question.
to have a day, you just trying to enjoy the deliberate.
Claire, your wife is an elected official. She's running for office. She's on the ballot, and she has an obligation to take questions.
Playground, please.
This drama that she is somehow being harassed by somebody asking her a question says a lot more about her than me. One of the things I did at the Claremont County Fair Parade setup area was try to interview the two judges that are up for election in municipal court, Nathan Little and Katie Terpstra. Here's footage of both of them. Nathan Little he doesn't like me, but he's a gentleman and takes questions.
Why is the video not on?
Or
Yeah, it's a video and it's not on the
I don't
screen.
see any picture.
I'm going to replay it then if it's... So he's not supposed to have the camera on it, I think, but the video should be up on the screen.
Well, all I'm seeing is a screen. Well, let's move on.
I'm not going to... I want to play this video.
I know you want to play it, but I'm saying that...
He's right there.
Who's right there?
The person who's going to fix it.
Oh, if he's right here. Okay.
Okay. All right, I'm going to start it again.
Thank you, as always, Nathan.
That's Judge Nathan Little. He's a colleague of Judge Terpstra.
Okay.
Thank you, as always, Nathan. I know we don't see eye to eye on a lot of things, but you're always a gentleman. Thank you.
I've known you for 8 years.
Thank you.
Yep, I appreciate it. Yep.
I just want to ask her how her judgeship is treating her so
I have no comment
far.
for you now or ever. You can stop harassing my family now.
I'm not harassing in any way, and you're a lawyer, and you know I'm not harassing by asking you a
We're just
question.
trying to have our day here, just trying to enjoy the deliberation.
Blair, your wife is an elected official. She's running for office. She's on the ballot, and she has an obligation to take questions.
Playground, please.
This drama that she is somehow being harassed by somebody asking her a question says a lot more about her than me. One of the things I did at the Claremont County Fair Parade setup area was try to interview the two judges that are up for election in municipal court, Nathan Little and Katie Terpstra. Here's footage of both of them. Nathan Little he doesn't like me, but he's a gentleman and takes questions. Katie Terpstra literally appears to be mentally disturbed, and her husband mentally disturbed, that they will not take questions in the way they act. They're at a campaign event, at a parade. I come up and ask some innocuous question, and she goes crazy, shaking, filming me. I'm not sure this woman should be on the bench, frankly. She was put in as a crony because of her support and service in the prosecutor's office, who, by the way, still list them on their online org chart. But watch the video. Nathan Little versus Katie Terpstra.
We have no interest in talking to you. Have a good day.
Judge Terpstra?
You can stop harassing us now. Thank
It's
you.
not harassing. I have a right to ask questions to an elected official.
Yeah, you can go ahead and go talk to somebody.
We've asked you to leave. Stop harassing us.
I
Now
can't.
leave.
You have no right to ask me to leave.
Chris, just leave.
I just want to ask her how her judgeship is
I
treating
have
her
no
so
comment
far.
for you now or ever. You can stop harassing my family now.
I'm not harassing in any way, and you're a lawyer, and you know I'm not harassing by asking you a
We're just trying
question.
to have our day here, just trying to enjoy the deliberation.
Blair, your wife is an elected official. She's running for office. She's on the ballot, and she has an obligation to take questions.
Playground, please.
This drama that she is somehow being harassed by somebody asking her a question says a lot more about her than me.
Okay, Chris, just get out of here. I mean, whatever it is you think you're doing is...
I just want to ask Judge Terpstra how her...
I've already told you I have no comment for you now or ever. You can leave.
Now or ever. So you're a judge in Claremont County, and you refuse to take any questions.
Yeah,
From you?
Yeah, absolutely ever. You can go ahead and leave and do whatever else you're going to do today.
Okay.
We're just trying to enjoy our time here at the parade. You can get out of here and harass and
I'm not harassing anybody, and your wife should know the legal standard for harassing.
we're asking
She's
you
a public figure, an elected official. I asked her a simple question.
Chris, come on. I mean, just be a regular human being for once and get out of here.
How about your wife and you being regular human beings, and when citizens ask questions, not treating them like dirt.
Chris, maybe any other human being or citizen, but you can leave, okay?
I don't think you have any authority to tell me what to do here.
So
I asked your wife a
stand
question,
here like a psychopath,
and you can record me. You can do whatever you want. I have no problem with that.
All right, great.
I just asked you a
So you can spend
question.
the rest of your morning standing here and recording me. I've already told you I have no comment.
I think the concern is that that the people in Claremont County are questioning a municipal court that has been deluged by scandal. You were appointed with no opposition. You have no opposition now, and you won't take any questions.
We are never going to talk to you, Chris.
There's a reason why a lot of lawyers won't practice in Claremont County anymore.
I have no
It's
comment
because
for you
potentially of a judiciary who won't take questions.
I have no comment for you now or ever.
All right, folks, so this is Judge Terpstra. She's on the ballot in November. She won't take any questions from any press, citizens, otherwise.
No, from
Well, when are you doing an interview with other press? So if I get Derek Myers of the Scioto Valley Guardian to request an interview, will you do it with him?
I have no comment for you.
So you understand, Judge Terpstra, if you cared about the Constitution, that the point of the press is to hold elected officials accountable.
Chris, you're not
wanting. When have you ever done an interview with the press? When have you ever taken press questions?
No one. We're never going to talk to you, Chris.
That's fine. That's your prerogative, but it's my prerogative to keep asking questions.
Stop harassing.
I was never on your property. You appear to have some issues that you claim things about people that are false. Do you do that in your court? Do you claim false things?
You won't just leave and go.
Do you claim false things about your...
Chris,
because Ms. Terpstra, as a judge, has an obligation to the citizens. And when she's refusing to take citizens' questions, when she's up for election, when she has had no opposition, then this is the behavior. This is why people are concerned with our courts and concerned with, frankly, Blair, an attitude of arrogance, entitlement, and elitism, an imperial judiciary of Claremont County.
The fact that you won't move on, there's something wrong with you, man. Get out of here.
There's something wrong with me because your wife won't take questions.
We're trying to be here with our family and friends, and I mean,
aren't you here campaigning? Aren't you here? This is not a cookout in a park. This is campaigning.
Just ever. Get out of here, Chris. You're ridiculous. You're absolutely ridiculous.
How is everything at Princeton?
I mean...
All right, so people, this is the judiciary in Claremont County, refusing to take any questions, complete arrogance, no opposition on the ballot ever, because the system is rigged. So, making false claims that I was on somebody's property that I was never on.
I never said that. I said you trespassed from our property because you recorded from my house. So now move on and stop harassing my family.
All right. So Ms. Terpstra, because she refuses to take any questions, it'll just be more focus on why we have judges that refuse to take any questions.
Get out of here.
What is wrong with you? I'll be back.
What is wrong with you, Chris?
What is wrong with you? You're a government employee for a school district. You know the law. You say you believe in the Constitution, but your wife refuses to take any press questions at all. So are you going to put me in a false light, Blair? Is that the goal?
A false light? How is it a false light when you accost people who are just trying to live their lives and have a normal day? Chris,
this is a campaign event, isn't it?
What's up, Chris?
Hey, Nathan, how you doing?
Good, how are you?
How was your week? What kind of caseload? Last time I talked to you, you told me about the pretty big caseload you have.
Yeah, I had, it changes.
I know you can't talk about individual cases, so I'll figure out how to ask questions that are not case-specific.
It's pretty common to have 20 or 30 cases a day.
Okay.
Friday was a little lighter, but...
And then, I came...
Are we about finished with this?
It has 2 minutes and 43 seconds left, and it's very important because this person uniquely won't do interviews with me versus a colleague here, her Judge Nathan Little, who does, and Judge Anita Beckman has done interviews with me. She is unique, so I want you to compare and contrast in the report that she found offensive the behavior of one of her colleagues towards me.
I think...
Recorded part of your courtroom. It seems like you do in the...
Let's watch the rest of it.
morning you do certain types of activities, and then in the afternoon is when you do trials.
Correct.
Maybe just explain kind of is that common for judges that they do the morning certain activities and the trials in the afternoon? And
I can't speak for other courts or divisions, but in municipal court, yes, our arraignments, or typically what happens. We have 5 courtrooms. Those courtrooms are usually going all at the same time. So it's a busy place. I think we're the busiest county building, actually, that building. And so in the morning, those are my plea trial settings. And then the way that's set up, 8:30, 9:30 dockets are going to be people that are public defender represented typically.
Okay.
10:30 dockets are where they have private counsel. So that's reserved for private attorneys. And then typically that'll take you up to 12. So by that time,
then it's like a lunch break.
Around 12. And then 1 o'clock is always the trial. So motions to suppress, any trials that are before the court, and it's not uncommon that we have 2 or 3 trials a day, and some motions to suppress.
And what percentage of those trials are jury versus bench trials?
So municipal court, that's kind of depends.
Okay.
Obviously, I know we have some jury trials. I have some jury trials scheduled, but my experience being on the bench for 10 months is things tend to get worked out before the trial actually gets started.
Okay.
So I dislike that when it gets resolved that morning where the jurors have already been called and they're there ready to be, seated, but that's still.
So the one and only time I recall ever being called for jury duty where I had to go in was a common plea, and the person changed their plea to guilty or no contest while we were waiting in the jury room.
And that's exactly what I'm talking about.
Yeah, and somebody said that people will do that sometimes because they're kind of, maybe they're guilty, but they're so hoping that a witness or an officer won't show up.
And I think that's true. And you see that in some of our cases too, where they will wait to see, if it's a domestic violence or an assault or something where there's a crime of violence and there's a victim, they want to see if the victim shows up. The police will be there, but the police didn't actually witness the event.
Right.
And so you are right that is.
Okay, last question. How's the campaign going?
It's going fine.
You think you're going to win?
I hope so.
Just so everybody knows, there's nobody on the ballot against Mr. Little or Ms. Terpstra.
That is true.
So I think they're going to win unless,
Filing deadline was, May 5th.
Okay. All right. Thank you as always, Nathan. I know we don't see eye to eye on a lot of things, but you're always a gentleman. Thank you.
I've known you for 8 years.
Thank you.
Yep, I appreciate it. Yep.
Okay.
As potentially of a judiciary who won't.
I want to position this on one thing and ask a question.
What time do you normally quit?
Okay. So I left that one image up there. So is this the interaction we had at the fair?
Yes.
Okay.
The portion with me, I should say. The portion with me in that video.
Okay. And there was another portion that was your colleague, Judge Little, doing an interview with me, correct?
It appears so, yes.
And you were both on the ballot in the same election, correct? And you were both at the same campaign event, Fair Parade, correct?
We were both at the Fair Parade.
Okay. Mine. Okay. Are you familiar with what's in that particular image up there?
Yes.
Okay. Has your husband run against me for political office on more than one occasion?
I'm going to sustain that.
Well, this is very relevant
I'm sustaining the
because
objection.
this is why she has a certain view of me, because I've beat her husband multiple times in elections.
Objection sustained. Sit down.
Judge, I observed, I guess that was maybe a 5 or 8 minute video. And Mr. Hicks came up to you.
Yes.
And you indicated you did not want to talk with him.
Correct.
Do you believe that you had the right to tell him you did not want to talk to him?
I do have that right.
And did you explain to him that you did not want to talk to him?
Yes.
And was your husband present?
He was.
And were your children present?
They were not initially. They ran up at one point, as you can see in the video, and I sent them away because, again, concerns of how he will react, how he will lash out. I don't want my children involved with that. And repeatedly, when he has displayed this video, he has chosen to crop it to only the portions with my children in it.
And would you say that you, at least repeatedly, for the entire length of this video, which may have been as much as 8 or 10 minutes, you repeatedly told him that you did not want to talk with him?
Correct.
You repeatedly asked him to leave you alone?
Correct.
And he repeatedly insisted on putting a microphone in your face and continuing the conversation?
Yes, and I will additionally add, you can hear at one point we discussed that he had been trespassed from my home. This was from a background or a context that approximately 2 months earlier, he had posted a video outside of my home describing, this is where Judge Terpstra lives. I essentially, I'm paraphrasing here, think she's crazy. If you have a grievance against her, contact me. And so at that point, I asked the police, Union Township police officers, to inform Mr. Hicks that he is trespassed from my residence, that he's not permitted to be on my private property.
You were a prosecutor for how long?
I was a prosecutor for approximately 12 years.
Yeah. You and I actually fought a lot, didn't we?
We sure did.
Yeah, we did. And would you agree with me that your reputation as a prosecutor, as a trial lawyer, your reputation was that you were a pretty tough little cookie, wasn't it?
Yes.
Okay. And that you could more than hold your own in the courtroom?
Absolutely.
And you weren't intimidated by the process or by the lawyers or anyone else?
That's correct.
Okay. So you're pretty seasoned, you've been around?
I have.
All right. Watching you interact with Mr. Hicks in that video, with your husband and your children in the area, and everyone else watching, and you repeatedly asked him to leave you alone, did that cause you mental distress?
I was distressed because, again, he is so unpredictable, he is so volatile, what he would do to my family members, multiple of whom were there, especially my children. Yes.
I don't mean to speak ill of my client, but do you believe that Magistrate Little, would you characterize her as a tough cookie?
I think she can be. I think she has a very sweet disposition, a very sweet nature. You know,
I know.
I would say maybe between the two of us, I would win a toughness contest, but I think she has a very good disposition for the bench and the position that she holds for our municipal.
Well, I'm not suggesting that you don't have a good disposition, but you understand my point.
I do.
That for someone to make you feel mental distress or feel threatened, there has to be a reason, doesn't there?
I've stood across from actual rapists, murderers, and all of them have behaved more rationally than I've sometimes seen Mr. Hicks behave.
And there are those that would say that I can be pretty aggressive and confrontational in court.
I would have to agree with that. I am under oath, Mr. Constable.
Were you ever emotionally distressed or mentally distressed or afraid of me?
Never once.
And you believe that what Mr. Hicks showed here is his exhibit, and I'd like to have that admitted into evidence, Your Honor, whatever that exhibit number was. I'd like that as defense exhibit numero uno.
It's already in my exhibit.
That in living color.
What is the exhibit?
It's exhibit, I already said that, but it's exhibit, what did I say, Q? Yeah, exhibit Q.
Q.
Yeah.
That video that we just watched shows in living color the conduct that Mr. Hicks is known for and that makes people uncomfortable.
Correct.
Do you believe that even as a public official, you have the right to tell someone that you don't want to talk to them?
I do, and I think even as public officials, we do not have to accept harassment from people.
So on this occasion, it was your choice not to talk with Mr. Hicks.
It was.
And he refused to respect your wishes.
Correct.
And continued in a, would you dispute my observation that I believe that he was confrontational in that 10-minute video?
Yes.
That he was.
I do not, let me clarify, I do not dispute that observation. I personally felt that he was being confrontational and aggressive in that video.
and relentless.
Correct. And I don't know if you could tell from the video, but at that time I was about 8 months pregnant.
Yeah. Well, that didn't matter to him, did it?
Sure didn't.
All right.
I redirect. By the way, would I have any reason to know that you were 8 months pregnant?
I mean, I'm very visibly pregnant. And that's-
Okay, I'm sorry. Did you tell the electorate that you were pregnant when you were running for office?
Objection, Your Honor.
Sustained.
Okay, well, he said.
Sustained.
Okay. You said that under oath, you said that I somehow have cropped that video to focus in on your children?
I've said that in other postings that you have done, because I know I've had to do multiple requests to have still frames and videos removed where you've used that video, that you have specifically focused on the few seconds that my children are in frame. And you have not made any attempt to blur or hide their images, and I do believe that is an attempt to harass me.
Do you have any evidence of that? Can you produce anything to show me that? Because I'm unaware of any cropping I've ever done of any video.
He's not a witness, he's testifying. He can ask questions.
I asked a question.
Don't interrupt me. He can ask questions, and it's too bad if he doesn't like the answers, but he's got to live with them.
Mr. Croswell, I understand that, but he was asking a question which was somewhat premised on what he claims his experience was. I did not think it was an improper effort to ask the question, so ask the question again.
Do you have any evidence of this supposed cropping of video to focus in on your kids that you claimed under oath that I did?
I don't have to prove anything here today, so no, I did not bring any evidence with me, but I do know from my personal recollection and my personal testimony is that I've had to make multiple requests to social media outlets to have videos and still frames removed, Facebook, YouTube specifically, because you continually use video footage of my children without blurring or hiding their images.
Okay, but you said I cropped in video to show images of your children. That's what you claim under oath.
I use specifically the portions of that video that include my children, as that video is, again, about 5 minutes
And you're
long,
saying that
and you could have used any portion of the video other than the portion that contains my children, but every time you post or display that video or a portion of that video, it includes my children.
So, Ms. Terpstra,
My personal belief is that that is your attempts to harass or manipulate or intimidate myself and my family.
so if I had the interpretation, or a citizen had the interpretation, that the focus of the camera and the discussion was you, and your kids just happened to be milling about wearing campaign T-shirts, would that be an unreasonable belief for a person to have?
Objection, argumentative, it's his own witness, it's not relevant or material. You've seen the video yourself, Your Honor.
I just want to hear the question.
Would you think that a reasonable person could look at that same video, or whatever those frames are that you're claiming, and say that the focus the whole time in the video was either you or your husband, and your kids might have been inadvertently roaming around, but at no time is there any attempt made to focus on your kids or anything of that manner? Would that be a reasonable judgment for a person watching that video to come to?
I can't testify to how other people view that, but I know for a fact that myself, my family members, my close colleagues, when they view the portions you choose to use, which are, again, the approximately, 10 or 20 seconds that my children are viewed in that video, and you constantly use that portion, and you constantly refuse to blur their images, to the point that I've had to have them taken down multiple times, so you're well aware of the issue of posting someone else's minor children online without the consent. When there are multiple other moments in times within that video that you could choose to use instead that would not include my minor children, that yes, I think that most people who are aware of the situation, aware of who you are, aware of your predilections, do think that that would be a conscious choice by you in order to...
Okay, so you don't have any evidence. You don't agree that a person could believe that the focus was yours, and you don't, and you think that I should use other frames, even in whatever you're talking about, but those other frames wouldn't have involved my interaction with you, which was the focus of the whole conversation.
Your Honor, objection.
Sustained.
So,
We're done.
Okay.
Finished.
Well, I was going to ask her about campaign events, but...
We're finished.
Okay.
Thank you, Judge.
Oh, by the way, Your Honor, I would have liked to play the video that you already declined before,
which was the video that she claims that I was in front of her house on. So she's made all these claims, and I'd like to play videos so she can refresh her memory of what happened in those videos, and I have a video of that. Can I play that?
We're finished with this witness.
Okay.
Can I be excused from
Yeah.
my...
All right.
So the next,
What time is it?
3:33.
All right. They normally finish about 4:30 here.
Okay. So the next, I'm going to cross off the ones that are already gone. The next witness I'd call would be Patrick McCracken.
I'm okay. Nobody else seems to be
You want to take a break?
discomforted.
Did you want a break?
Well, I use the restroom, but.
Well, yeah, Judge, can we,
At 4:30 when we leave, so I guess.
you want to a break?
Yeah, I need to go.
Judge, can we take about just a 10-minute break?
I thought you'd never ask. Sure.
Well, I'll ask every hour. This old guy.
I understand.
Yeah, there you go.
Father Time has given us the blessing of long lives, but
Yes, sir.
has restricted our
Yes, sir.
faculties a little bit.
All rise, this court stands in recess.
Your Honor, may I be heard on just a couple of housekeeping matters?
Sure.
Thank you, Your Honor.
You are back on the record.
Okay.
Thank you, Your Honor. Brian Schreiber on behalf of the prosecutor's office. I just want to let the court be aware. I was in the hallway. I spoke with the police chief from Peebles, who's on a witness list, and he just advised me that he needs to go and he is not available tomorrow. And so I just wanted to give the court that information.
Yeah, I mean, just from a housekeeping standpoint, I'm not available tomorrow either. I mean, if this gets continued, it's going to have to be to a time in the future.
Well, we're not going to finish it today.
Well, I understand that, and I mean, traditionally, these take an hour and a half. This is not the traditional one. I just am not available
When the
tomorrow.
Supreme Court called me and said, "Will you go down to Claremont County tomorrow morning or tomorrow afternoon," or whatever it was, I also anticipated about an hour and a half.
Well,
So,
just as long as we can pick a new date after this is over today.
But you're not available tomorrow?
I'm not.
All right.
And then,
Well, we can bring the People's Police Chief.
Your Honor, at this time, I'm going to object to proceeding in this unusual fashion of my witnesses as an accommodation to this court going first. They have the burden to put their case on. I accommodated the court because of some of these witnesses, but I'm going to object to any further continuing of my witnesses being called before he's done his case.
What about the People's Police Chief?
Based on the demeanor of the court and the responses I've gotten, I'm objecting
What's
to any...
the demeanor of the court that concerns you?
Well, I'm objecting to any continuation of me as an accommodation, having witnesses of mine go before he's presented his case in chief. I thought that could be an easy accommodation, but we've gone from people to confirm a few things into claims being made by people that I have some sort of mental illness, pattern B or something like this. So it's gone far asunder. So I tried to accommodate the court, and I thought it was a reasonable accommodation, but at this point, I object to proceeding with any witness until he has presented his case in chief.
Well, so you're objecting to the People's?
I'm objecting to proceeding with any witness until it's his case. He has the burden of proof. He's supposed to go first. I accommodated this court to do some perfunctory witnesses up front that I thought would be minor and de minimis witnesses, but that's gone to a whole different thing when there's allegations being made about my mental health. So I am saying at this point, I object to continuing this accommodation of my de minimis witnesses going first. He has the obligation to present his case in chief first, and then I present my case. He has the burden of proof. I don't.
I agree with you, and if you don't care to accommodate,
I have accommodated.
further accommodate these witnesses who are under subpoena, I understand that. Now, the People's Police Chief can't be here tomorrow.
To be clear, Your Honor, I'm not representing him. I'm just, as an officer of the court, advising the court. Yes.
I think what we'll have to just, everybody out there then who's been called as a witness, and I don't think they're going to testify today, Mr. Hicks, because we're going to leave somewhere around 4:30. So, and if they start putting on a case, then of course that will
Correct. Your Honor.
take care of the time. They are still under subpoena, and then you would have to be in touch with them as to when they should be here. And now I know you probably had them all come in at 1 o'clock today because that's the way subpoenas work. But I think you recognized that you need to take some steps to minimize the amount of time they lose by being witnesses under your subpoena.
I don't disagree, however, Your Honor, I have a right to defend this case.
Yes, you do.
And so the witnesses that I call, the notion of, I don't even know what you're asking me. Like, I need to give them a time schedule for when to show up so that they don't to minimize their disruption of their work.
I thought you submitted with every subpoena a copy of a rule of civil procedure.
Yes.
That put a burden on you to minimize the inconvenience to witnesses that you have under subpoena.
And I've done that. That's why I tried to accommodate doing these first witnesses quick,
well,
to get them out of the way, right, Your Honor?
To do that
but
as
he
well.
has the burden to present his case.
That. All I'm saying is, we'll have Mr. Criswell begin to put on his case, but it'll be up to you to work with your subpoenaed witnesses to get them here when they need to be here without any unnecessary additional time on their part.
I don't know that, okay, I'll say I understand, but I don't know what you mean by unnecessary additional time.
Well, first of all, let them know when you expect that you will call them.
Okay.
So that if you think you'll call a witness at 9 o'clock in the morning, the person will be here. But if not, don't have them here at 9 if you're not going to call them until 11. That's all I'm saying.
Okay. Now, Your Honor, one other thing is I want to be able to, before we leave here, address my motion of revocation or vacating the current ex parte order that's keeping me out of courtrooms, keeping me out of this. So I want to make sure we have time to deal with that motion. If this is going to be continued, I'm currently suffering irreparable harm by being locked out of things that I report on because of the broad nature of what you did. Frankly, I don't think there can be any restriction in what you do in an ex parte that would be contrary to constitutional rights. But further, there's a specific part of the statute that addresses the criteria for even issuing an ex parte that were not even remotely met in the ex parte hearing.
And what was that?
Well, there has to be a threat of violence or harm. That's it's
a pattern of conduct.
No, you're confusing menacing by stalking with the actual the statute has a specific section on what's required for the issuance of an ex parte that is a higher bar. An ex parte can only be issued, I'd advise you to read the statute. So the statute is, if I could find it here, I just want to make sure to argue, to deal with that motion before we leave here. And if, Your Honor, I'd encourage you to be familiar with the actual statute, because there's a whole part of the statute that has requirements unique and distinct from menacing by stalking for the issuance of an ex parte order.
Well, what's the statute you want to refer to?
Hold on, let me find it here. I got to find it on my exhibit list. It's in that motion, but it is... It's Exhibit R in the packet that I gave you.
No, maybe that's a help.
So if you go to Bates Base stamp number 70. And this was argued in the motion as well.
Did you say what the statute was, Chris?
It's 29, it's in that packet I gave you.
What is it?
It's 2903.214,
Thanks.
section D1, which is on base stamp page number 70.
Thanks.
So if you start, you see D1 there? Starting the third line down, it starts giving the requirements for the court to issue an ex parte. And you'll notice it says that the court finds necessary for the safety and protection of the person to be protected by order, immediate and present danger to the person to be protected by the protection order constitutes good cause. So for the granting of an ex parte, the standard is supposed to be that there's an immediate and present danger, which is also supported by case law that is referenced in the motion that I filed. Because remember, ex parte is just that brief time period before the full hearing, and the court's only supposed to be issuing ex parte orders when there's an immediate danger or threat.
Well, Your Honor, with all due respect, you've already determined by granting the ex parte motion, you've already determined that fact.
I filed a motion to vacate that, pointing out to the judge that there's an error in that motion because she actually testified in the ex parte that she had no threat. So you'll see there, Your Honor, it says immediate and present danger includes but not limited to situations where the respondent has threatened the person to be protected by the protection of bodily harm, sexual offense. So there's actually a higher bar on the court for issuing an ex parte order than for issuing a full protection order, because it has to be based on an immediate danger. And if you look at the motion, it actually cites case law relating to that as well. And the statute's quoted in the motion that I filed as well. And there's transcripted excerpts of your ex parte hearing that do not meet the standard of the statute nor the case law.
Well, it does seem to, it does say, as you have indicated, Mr. Hicks, that immediate and present danger includes situations in which the respondent has threatened the person to be protected with bodily harm or in which the respondent previously has been convicted or pleaded guilty to a violation of 2903-211.
And I'll draw your attention. I'll just say from the motion, page 3 of the motion, quotes case law, Kofus versus Lukart. An ex parte order requires petitioner to show good cause and specify showing immediate and present danger. So my argument on the ex parte is that there never should have been an ex parte because the statute specifically requires immediate present danger. And in your own questioning, in the use that you asked to kind of cut to the chase here, are you saying, let me just ask you, has he ever threatened you with physical harm? And her answer was not physical harm.
Then I agree. That's what she said.
Yeah.
Your Honor, if I may interrupt that, I think I mentioned I had two housekeeping matters.
Yeah.
First was the witnesses, and once I'm done with the second housekeeping matter, if the courts leave, I will let those witnesses know that they can leave, but expect to be called back at a future date.
Yeah.
Thank you, Your Honor. The second housekeeping matter, Mr. Myers, who's recording, I noticed, and first I don't impugn, I'm not questioning his integrity. I did notice, you'll see there's a phone kind of camera and then a camera. I noticed that the monitor on the camera at one point did include Ms. Terpstra when she was on the stand. I mentioned that to Mr. Myers. He indicated that camera was not recording or broadcasting at that time. I just wanted to make sure that was on the record and that Mr. Myers would go on the record to confirm that he did not get it.
If I may, Your Honor. When this gentleman approached me and had this question about the witness being on camera or if she was being recorded, she was not being recorded in any manner. We've got multiple different devices here, Your Honor. Just because one's pointed one direction doesn't mean it's actively turned on or recording. It would be no different than if we were at a homicide scene. Just because we have a camera pointed at a decedent doesn't mean we're taking pictures of the deceased.
I think I would ask, Your Honor, that in the future, all cameras be pointed away from any witness who requests
Your
not
Honor,
to
there
be
was no
recorded.
witness, once they objected and you ruled, there was no witness that was ever even filmed. In fact, when they left the courtroom, Your Honor, we moved the camera. I even took the liberty to move the camera to the respondent and petitioner's table, so the people would not even see the witness walking out.
Again, I understand that, Your Honor. My point is the camera was facing her, and the monitor on the camera did show her.
Your Honor.
And I understand it wasn't recording, it wasn't broadcasting, but it was still aimed at her and could have been. And I think
But it wasn't, Your Honor.
again, Your Honor, I'm
What's
asking
his basis?
for clarity's sake that the camera needs to be pointed away from any witness.
That's ridiculous, Your Honor. It's not, you're, with all due respect, Your Honor, you are presiding over this courtroom, and this is your court, and you make the rules of today in compliance with the rules of procedure. We have to be able to have a camera, as it is right now, parallel focused on you. It's zoomed in on you. I'm looking at a lens. I'm looking at a camera lens right now. I see you. I do not see the witness chair. This is not going to move left or right if I show you or a witness. If a witness objects, I still need to have my camera pointed this way to show you, Your Honor. So merely the position of the camera, if he has a problem with that, then he should file that. If this is going to be a continued hearing, Your Honor, with all due respect, he can do a motion to intervene or bring some sort of petition before the court. But we are obeying the court's orders as you have ordered them, and we have not shown any witnesses after they've objected.
Well, if you're representing to the court that notwithstanding the current positioning of that camera, none of the witnesses who asked not to be had their picture taken, that did not happen. Court is satisfied.
Correct, Your Honor. Once objection was made, they were immediately removed from view of the cameras, and even when we did a courtesy, even when they exited the room, we made sure that they were not on camera when they were exiting the room.
All right. Well, as long as you continue to abide by that protocol, the court is satisfied.
Yes, Your Honor. I just would note for the record, Rule 12 is written in the manner that it is written and changed in 2025 because of myself. So I'm very familiar with Rule 12.
Very well.
Thank you, sir.
Thank you, Your Honor.
Okay, thank you.
And I will let the witnesses know that they may.
Yes, yeah.
Do you, Mr. Croswell, I guess you'll be calling witnesses or anyone else? Do you need me to keep?
What is your reaction?
Your Honor, my reaction.
Now, the court issued an ex parte
Right.
order, but the court may have issued an ex parte order without sufficient evidence to support an ex parte order.
And so you want my reaction to that?
I do.
Okay, well, very well. Your Honor, to begin with, my client testified that in the ex parte hearing that Mr. Hicks did tell her in a menacing tone there will be ramifications, and that based upon that statement that he made in a menacing tone, she was concerned for her safety. That's number one. Number two is that if you read the statute says that the court for good cause shown at the ex parte hearing may enter temporary orders with or without bond that the court finds necessary for the safety and protection of the person to be protected. Now, then there's a period. Okay, so the first sentence says that you may issue it for their safety and protection. After that, it goes on to say that
Where are we? On the-
you're in you're at
70, page stamp 70.
you're
D1,
29. We're
that's
29. We're 29. 07.
Page stamp 70.
Yeah, well, you have to look at the statute, though. We're at,
We already said it once. That's 29. The statute's 2903.214 The section he's referring to is D1. It's page stamp 70. In the motion that I filed, it is page 2. It's pasted onto page 2. It's easier to read in the motion than in the handout.
So if you read that, when you read the statute, and I've not seen his motion, so I've not read it, so I assume you're telling us you did quote the statute directly.
Yeah.
I don't know. I mean, I take your word for it. So the statute then, Judge, reads, the statute says that the court for good cause shown, at the ex parte hearing may enter temporary orders with or without bond that the court find necessary for the safety and protection of the person to be protected by the order. Now, for the safety and protection could be any number of reasons, one of which would be to stop someone from causing emotional stress to someone. The statute then goes on to say...
Your objection to his characterization of the statute speaks for itself. The judge should read the statute and it speaks for itself without your interpretation of the statute.
Chris, Mr. Hicks, please stop interrupting me.
I made an objection.
Well, the objection is...
Judge, I mean, like I tell you before, all we need to do is mark him as an exhibit in our motion, and that pretty much tells the whole story.
Well...
It goes on to say that if there... that immediate and present danger to the protected person does constitute good cause. But it doesn't say that that's the only reason it could be issued. It doesn't say that's the only reason it can be issued. It said it can be issued for the protection of the moving party, of the petitioner. And you've issued an order based upon the totality of her testimony that she said that he was causing her and would continue to cause her severe emotional stress. And I just asked the court what the court thinks will happen if the court removes this ex parte order and permits him to have contact, unfettered contact with the petitioner in this case. I just asked you, based upon what you've seen here in the last 3.5 hours in that video, what you think that will lead to. And what I'm suggesting to you is she's entitled to live in peace. She's entitled to not have a person engage with her and cause her imminent or immediate mental distress. And what I'm suggesting to the court is that while Mr. Hicks may have his rights, she has rights too, and she has the right to be left alone by him. And I can guarantee you, if you remove this ex parte order, the next move he makes will be to start harassing her again.
Well, the statute says immediate and present danger to the person to be protected by the protection order constitutes good cause for purposes of this section. Immediate and present danger includes, but is not limited to, situations in which the respondent has threatened the person to be protected by the protection order. So, I don't think that the statute requires that he has threatened the person with bodily harm, or in which I don't think that's...
It doesn't.
I don't think that's the exclusive basis.
That's my argument.
So on that reading of the statute, the court would not vacate the ex parte order.
Your Honor, it's now 4:10.
Yeah.
And this is obviously going to take, I thought, so it's obviously going to take another day.
Yeah.
So I'd ask that we break today and reset this matter so that my client's testimony can flow in its entirety, as opposed to going for 10 minutes here.
What I do think that there is some basis for relaxing the restrictions in terms of where he can be. In other words, the courts are public, they're open. And it just seems to me that he ought not to be harassing this woman in any way. Whether or not his conduct is harassment is yet to be determined. But I do think that the fact that she is operating in a public courtroom, which is open to the public, allows him to at least be present there, notwithstanding that that may be very uncomfortable for her.
Well, if someone had threatened, for instance, your life, and there was an open and pending charge against him for threatening your life, do you believe that he would be permitted to come in your courtroom and sit and watch other proceedings?
Well, now, remember what these threats consist of. I mean, he has not threatened her with any physical harm. What he basically represents is a threat to make her life miserable by asking her questions that she doesn't feel she needs to answer, and then maybe sending her emails, and then I guess putting things on the internet that say she refused to answer. It's just part of a big cover-up. But that's...
Going to her house.
Well, now...
Going to her house, telling her there's going to be ramifications.
Am I allowed to be part of this discussion? It's my motion.
Now, you're ahead of me.
Okay.
I talked about public spaces.
All right.
Okay?
Sure.
I talked about public spaces. We haven't gotten to the house yet. And whether or not that going to the house, based on what I believe his explanation is, was conduct that supports a finding of pattern of conduct remains to be seen from the evidence. But I do think that the evidence is clear that she's very upset and that he ought to be barred from going to her house.
Well, may he be barred? Can he be barred with being within 500 feet of her?
Can I be part of this conversation, or is this between you two?
Look, why don't you wait your turn and stop interrupting me, all right?
It's my motion.
It may be your motion, but it's not your courtroom.
It's not yours either.
Now, Judge, if what you're saying is that you believe he should be permitted to go into public courtrooms, okay, fine. If that's your ruling, as opposed to Mr. Hicks, that's your ruling, that's your ruling. But he should still be barred from being within 500 feet of her if she's not in a courtroom. So that means that he can't follow her out into the parking lot, that he can't follow her home, that he can't do those things. The primary goal here is not to keep him out of the courthouse. The primary goal is to keep him away from her, 500 feet away from her. And you've heard testimony here today. You heard testimony from her, and you heard testimony from his witness, Judge Tepstra, who told you what his reputation is, the concern people have in this community, the things that he's done to people, and more importantly, Judge, you got to watch that video. Okay, and so what I'm saying to you is his conduct alone in that video would cause emotional distress to anybody, including Your Honor, if he were doing that, pursuing you and doing that and refusing in any way, shape, or form to acknowledge or respect your feelings that you don't want to be bothered by him. And so these feelings go two ways here. He, on one hand, wants to litigate what his rights are, while other people have their rights too. So if you believe that the courtroom is a public place, I'm not going to argue. That's fine. That's what you believe. But I believe strongly that ex parte order should stay in place to bar him from being within 500 feet of her otherwise. And let me suggest this to you, Judge. If he's arguing that there should not be an ex parte order to bar him from having contact with her, the only explanation, he likes to talk about only explanations, the only explanation for his objection to that is that what in fact he wants to do is take up his course of harassment against her. That's the only plausible explanation for why he would want that ex parte order terminated in the first place.
All right, your turn.
I just want to remind the court that I understand your ruling on the ex parte thus far. I think it's wrong, but I want the court to understand, for all the drama
my interactions with this woman ever, over entirety of time, have been when she did candidate forums with me when she was seeking appointment, and specific to this one case in Peebles. Specific to one case in Peebles. I've never been to her house before that. I've never been after that. I wouldn't have gone to her house if she would just acknowledge the Marsy's Law rights of the victims. I'm doing exactly what a Marsy's Law advocate in the Ohio Constitution is supposed to be doing, for the exact reasons the voters of Ohio voted by 73% to put it into the Constitution. I have no, by simply telling me I'm trespassed, which she should probably tell the police, if I go into her house, it's a crime. Okay, it's already a crime. If I've been told I'm trespassed and I go to her house, the issue here isn't my behavior. Since the 29th, what interaction have I had? I post reports on things, but I haven't pursued this woman at all. They want to paint this narrative of I'm chasing people around, I'm stalking their kids, I'm going to their houses. That is all ridiculous. It is all absolutely false. Here's the issue we have in play on his 500 feet thing. First off, let's start, before we get to the 500 feet, let's start with the public spaces. I think you appreciate now that your inadvertent checking a box theoretically barred me from the jail, the sheriff's office, every municipal courtroom, any Peebles government meeting. There was a Peebles government meeting I couldn't go to because I was afraid I'd get arrested if I went to the Peebles Council meeting because it's in the same building as her workplace. So these public spaces is one thing. Now let me give you another thing that happens. I am a media outlet and company. I go to events like Police Night Out's coming up with a big canopy and a big setup. Give away stuff to people. Meet people, greet people. We have to be really careful here because I think everything you saw in that video was 1,000,000% First Amendment protected journalism. A campaign event, a person on the ballot running for office, being challenged to take questions. That is 100% First Amendment protected journalism. You might not like it, might not be your style, but it's 100% protected journalism. If you have a protection order, by the way, I have this woman, apart from this People's thing, I never had any interaction with her other than at the time when I supported her for getting appointed to the municipal court, and she sought that support. Okay? So the issue is, let's say I'm at Sheriff's Night Out coming up. I have a big canopy set up. The watchdog wire has presences at public events. What happens if Jessica Little comes along? If you leave an order out there, now that would be at a public space of Batavia Park is where that event takes place. But we have a whole bunch of different summer events coming up in the community at which the watchdog wire has a presence and has had a presence for several years. The thing you need to be careful about, I feel like, and I think you appreciate that the original checking the box present a lot of problems. We can't create a bunch of other problems too. So already, if I would go to her house, I would be, if she's trespassed me, she should call the police and say she did. Okay? Then I can get arrested, right? It's a crime to go to somebody's house when you've been trespassed. If I disturb a lawful meeting, I can get arrested. Okay? I really have no interest in the woman outside of this Peebles case. It's kind of opened up a whole other thing with these mayor's courts and how they're operated, and I'll probably look at that closer across the 3 counties that I cover. But anything that you do, frankly, I don't think the ex parte should be there at all. I have your own testimony in your ex parte hearing, contrary to her 4-page write-up that was with the petition. In your actual hearing, her mental distress she described, if you remember, Your Honor, was that a co-band member in her community band saw an article by me come up on their feed, and a Daughters of the American Revolution person the next day told her that they saw an article. That's what she described to you when you asked her how it was impacting her. Your question was, how is this impacting you? And she told you those 2 things. You can already see there's a lot of passion in this county as it comes to me. There's a lot of passion in this county, and with good reason. I've caused probably half a dozen elected officials to lose their offices in Claremont County, or in the 3 counties that I cover would be a better way to put it. So whatever happens here, I don't think there was any basis for the ex parte. It's funny, for all these things I do, I've never been arrested. I've never had any criminal, even arrest record ever in my life. So this court needs to understand what's really going on here. It's about the suppression of speech. That's why, if she's so concerned, why didn't she take action on a protection order after I came to her house on the 22nd? Why did she wait until 19 days in an intervening communication from her lawyer demanding that I take down my reporting and that I never again attend any judicial proceeding that she's part of. It's all a tell. It's all a tell. So whatever you've already ruled that you're not going to take away the ex parte, which is going to continue to cause me irreparable harm. But as far as anything else, in his 500 feet, there's a whole bunch of other considerations here, because what's going to happen if I'm at an event and she shows up, and then what am I supposed to do? Scuttle the booth? And how many minutes do I get to scuttle the booth if she should show up at a public event? I don't know if there's like an Adams County or Browns County Sheriff's Night Out too. There are. I don't know which ones I'll be attending. I know the Claremont County ones that I've historically attended. But this is a very important thing in these matters. The funny part about it is, for all this stuff you've heard, the only contact I've ever had with this woman, subsequent to several years ago being in candidate forums with her that I put on for her, was all around this one case in Peebles. And it was all about one thing: trying to get her to acknowledge the Marsy's Law rights of the victims. That's what it was all about. Had she at any point in time just acknowledged that, like she did with Bob Finan, she replied to him, she didn't reply to me. So whatever the court's going to do here, I was going to point out that I had a motion to change the ex parte, okay, that I filed right after, like the day after. I think these were actually filed on the 17th. You had said the 18th on some of them, but
one was filed on the 17th.
Most all of them were filed on the 17th, and they were all filed together except for.
Well, one was filed on the 17th, and then.
You're right. One was filed the 17th, and a bunch of others the 18th, and then one on the 21st or 22nd or something. Yeah. So I filed a motion for change. At the time that I filed that motion, I had not heard her actual testimony in your ex parte hearing, where she testified on the record that she had no threats against her. And that when you asked her the specific question, how is this affecting you, went into a narrative about her co-band member having seen a news article, and about her Daughters of the American Revolution friends seeing a news article. It's an entirely different story. So I filed the second one, the motion to strike the ex parte entirely, after I listened carefully and analyzed that ex parte hearing, which I'm glad I did, because there wasn't the basis in there. In fact, you at one point, at the hearing, you actually cited an incorrect reason to Miss Hagee. You said to her, Judge, what the basic problem, and she says, okay, is that he continues to contact her in her professional capacity. By the way, I've not contacted her since May 29th. That's the last contact, because that was the last interaction. She moved the case to county court. It's done in Peebles. That's what's so funny about this stuff is all this hoopla. And then he says, you said, continues to contact her in her professional capacity, and also slam her on his Facebook page.
Yeah, that's what I said.
And that slamming her on his Facebook page is either outright First Amendment protected speech, or it is for a defamation or other claim. That is not the purpose of a protection order. A protection order is not a prior restraint. It's not the poor man's defamation. If she believes I've defamed her, or she doesn't agree with the report I put online, she has vehicles to do that. That has nothing to do with menacing by stalking. And so I believe that the court, even in its own statements when it was granting the ex parte, committed an error in stating the reason why you were granting the ex parte was because I continued to contact her, which was false, okay, and that I slammed her on my Facebook page. That's not the basis for any kind of protection order. So I still believe the ex parte itself should be set aside, but at a minimum, you need to figure out, more than the checkbox form, what you're doing here, because if she trespasses me, it's already a crime to go to her house normally. Okay, you don't have to, it's not a protection order thing, that's just trespass. And as it relates to 500 feet, I think you get the public spaces thing, but the 500 feet, you have to think of the ramifications of, I'm a media business. I have presence at different events all the time. Am I supposed to have somebody run around looking to see if Jessica Little's anywhere within 500 feet of the fair, of a booth at a fair? And if she comes within 500 feet, immediately start tearing the booth down to move out of there? Those are the kind of things that you're faced with dealing with. But frankly, I think the ex parte never should have been granted based on what was actually said in your ex parte hearing, which is part of the record.
Okay,
I just want to point out something too. I played an excerpt from the ex parte audio, so I would just like to make sure that the court agrees, because I have a little confusion because of the way these things work, that the ex parte, if that were to get transcribed, that is part of the official record of this case. That hearing is just as much of an official part of this case as this hearing.
I believe it would.
Yeah. Thank you.
So the issue is, how do we reconcile your desire to have a 500-foot distance between Mr. Hicks and Ms. Little and his right to public space?
Well, Your Honor, I don't know what you mean by public space. If you're talking about public spaces in courtrooms and official buildings, well, I understand what you're saying. But if you're talking about, out in the street here, that's not public spaces contemplated. I mean, look, the concern here is that he leave her alone. Okay?
I understand.
Right, and so, if frankly, if you would want to make the order that he stay 100 feet away from her, to keep him away. Now, and then we'll see when we come back. We'll see exactly whether he's honored that or not. I'm not trying to shut him down. I'm just trying to get him to leave her alone.
Well, I think what we need to say is that he shall have no unnecessary contact with her.
Well, how about no contact? I mean, because unnecessary is in the eye of the beholder, and
Well, I agree that that's a subjective sort of thing.
Believe me, she's not going to seek him out.
I understand, and I don't think he should seek her out.
Well, he shouldn't. So if you can fashion an ex parte order that basically says he's to have no contact of any type with her, and that, then that's fine.
Well, why don't we just say that then?
Well, as long as it's an ex parte order. I mean, as long as it's an order, as opposed to just saying it. I mean, if it's an order of the court.
What I'm saying is, we would modify the ex parte order to simply say that Mr. Hicks shall have no contact with Miss Little.
That's fine.
I mean, that gives you free reign. It just means don't bother this lady.
And I agree with that. I would like to just make sure that the term contact is defined. By the way, I'm not going to contact her anyway. I haven't contacted her, but the term contact would be, I just want to make sure that we've contemplated when I have a fair booth or a police night out set up, that she can't claim I contacted her. And Judge, it's very real for me, because in 2017, Commissioner David Ubel in Claremont County is the only other time somebody got an ex parte order against me. Okay, there's been like 4 people ever filed. This is like the 4th. Okay, and they tried to set me up. They had a conscious plan to get me to go into a meeting where he was in there so they could get me arrested. I want to make sure that doesn't happen. I'm a very law-abiding guy. That's what drives these people crazy, is that I don't do anything that's contrary to the law.
Well, Judge, if the ex parte order is that he had no contact with my client, and that he not attempt to seek her out, to go up to her, to talk to her.
That's all covered in no contact. So you're always editing these editorials.
Let Mr. Croswell finish.
Well, I'm objecting to the expansion of it into this demonizing language.
Judge, like I say, I'd just like to mark him as an exhibit.
Well, all right. This is
whatever the court.
All right. Let's just.
My goodness. That's what you want, is no contact. So he's not going to be around? Okay. Okay. He may even agree to that. We may not have to go through all this nonsense. He doesn't really want to be around you.
I didn't contact her anyway.
Pardon?
This is silly.
Trust me.
You know. It's all politics.
Well, I don't know about that, but you want me to ask you a question? As opposed to wrestling around and saying forever. Think about it. You're not objecting to just putting on you'll have no contact with her and move on.
We're going to go through this process all the way.
Well, I don't care. I mean, it doesn't matter to me. Oh, my goodness.
Well, how about just this simple sentence? The ex parte order is modified to prohibit any contact by respondent Hicks with petitioner Little.
That's fine. That's fine. Yeah,
Now-
no objection to that.
How about throwing in there, Your Honor, then that each party will agree to mutually not,
No.
hold on, I'm just wanting to deal with this, because it happened before. It happened
Well,
before.
what are you saying? What are you saying? You want
Is that if I have a booth set up somewhere, you know, and since she shows up, and then I get somehow jackpotted that somehow I violated some order because she came up to my booth, it has to work both ways. She can't do things that would try to create, because it happened to me, Your Honor. David Ubel tried to get me arrested by tricking me into coming to a meeting where he would be, where he'd already prearranged with the police there to have me arrested if I showed up.
Judge, this is just a continuation of the game.
No, it's the truth.
This is.
Go read the name for her.
She is the movement here, okay? You don't even have jurisdiction at this point to order her to do anything one way or the other. But I would just ask the court, what does the court believe the probabilities are of her approaching him? So
I think it's probably remote.
And so if he, look, and I would believe that if in fact, if the facts would be that she seeks him out, then I believe that he would have a defense to no contact order. Okay, I believe that. But that's not the point here. The point here is that the ex parte order is to order him to do something, not both parties. You don't have jurisdiction over both parties. And so you know, and a simple no contact order is fine. She's fine with it. He said he's fine with it.
Well, your concern, Mr. Hicks, is primarily somebody setting you up.
And I'm concerned, and the particular reality in the summer would be that all of a sudden I started thinking like a basketball game. When I got my position, my booth is set up at a event, then she has to have the decorum to not come into that, do things that would cause me to suddenly be afraid, because I would be the one to be afraid, that they are going to try to get me arrested when she's the one who came. So it's kind of like, you think about basketball, when I got my feet planted, and so if the watchdog wire is a business, is at one of these events, I'm not sure this would ever happen, but I am concerned because in 2017, there was an attempt to have it happen with Commissioner David Ubel.
Well, my suspicion is if it does happen, Mr. Hicks will have us right back here. You'll be driving down from Dayton, I'll be driving over from Cincinnati, and we'll be here.
Now, procedurally, I think what we've got as a practical matter is enough to satisfy your concerns, because frankly, I think your scenario is improbable in the extreme. I don't disrespect it, but I don't think it's likely to happen. And I don't think that some of the political intrigue will infect this. Now, my question is, how do we do this procedurally? Do we convert this to a final order?
Well, I don't think, as far as I'm concerned, if the final order was he had no contact with her, I'd be happy to go home and call it a day, but I think Mr. Hicks says he wants a full hearing on everything. So.
Correct.
In other words, to get out from...
To have no order, but that's my right as a full hearing.
All right, but as
to
of
get
this
to that point.
Oh, as of this, just a final ex parte order, yes.
No, it's
As of
not a
this
final.
point, the ex parte order is modified.
Yes.
I think it might, I'm not a lawyer, but maybe it's you're vacating the one and replacing it with a new one effective starting today.
Yeah.
That's what I think it's, you're vacating the old one, you're starting a new one effective today, and that new one is basically a simple no contact. And if any of this shit blows up in our face, we'll know it when we're back here for a full hearing.
That's fine.
To his point.
Now, let's let's put this on the calendar. You have indicated that you're unavailable tomorrow.
Judge, I'm unavailable for the next 2 weeks because I'm going to be back in town. I could do it on July 13th. If you want to do it, do you want to do it in the afternoons or all day? If you want to do it in the afternoons, I can do it. Let me look here.
Let me look at my calendar here.
I could do it on the July 13th, July 15th. I can do it on July 13th or July. If that works for Chris.
No, I'll tell you, that whole week is spoken for.
Okay, then I could do it. Let me see here.
How much time do we need?
Judge, I need about 20 minutes. I mean.
And
yeah.
Mr. Hicks, what about you?
I think I would need, just my examination of Miss Little will probably be an hour plus. Remember, she talked for an hour and 27 minutes in an ex parte hearing. So that the belief that we're going to have a full hearing and things are going to be super fast is not realistic in this scenario.
Well, that may be. He asked me. I think my evidence will take 15 to 20 minutes.
Okay. But what you're saying is that you have no time after today?
Not until the week of the 13th. And I'm not trying to be difficult. I have a family vacation scheduled. Yeah. I'm not trying to avoid it. I'm happy to. I'd be thrilled to get this over with.
So Your Honor, I think I object to anything that's not quick. Because my character and reputation is impugned no matter what, as long as it's standing out here. The fact that she obtained a very prominent lawyer from Cincinnati that's got vacation in a lot of other cases. I'm not accepting of these long, these long delays.
It's going to be up to the court, ultimately, as I think you understand. And frankly, as modified, you're still under the cloud of an ex parte order. I understand that. But except for staying away from Ms. Little, you're not restricted from doing anything.
But the fact that this stays out there and isn't resolved is causing me irreparable harm as a news organization.
I don't disbelieve you, but I'm telling you that I want to get this done right.
So when is the earliest day you can say you can even do this?
I said July 13th, which is 2 weeks.
July.
Judge can't do it then.
Unfortunately,
That's 3 weeks.
I am booked that entire week.
Okay, then I could do it.
I've got the 20th, which is a Monday.
I could do the 27th. I could do it the week of the 27th. I could do it the 27th, the 28th, 29th. If Mr. Hicks thinks it'll take a day and the court wants to start at 9 on
I think it wouldn't take more than a day. I mean, I think I'd start at 9. But I'd really object to this stretching it out and the reputational damage it's causing.
And that objection is noted. I mean, I don't. I'm not unmindful that you'd like to get this done, and you're the one who had the ex parte taken against you. I understand this. I could do the 28th.
28th. I'm good that day. I'm good that day. I have a couple other things, but I'll get some else handled. That's fine.
How about
the 28th? 9 o'clock?
I can put it on my calendar, but you already know my objection to more than a month in the future.
Hey, it's my wife's niece, sorry. It's like I'm having a discussion with her. Let's make it the 28th, and let's make it a 9:30 start time. That'll give me a chance to get down here.
We have protection orders in here probably until at least 10. Could we start at 10?
We can start at 10, and if we need to go a little late, we'll go a little late.
Okay, that'd be great.
Okay, so 10 a.m. And this is Claremont.
And you want the rest of the day?
Yeah, I think this will take the whole day.
Okay.
Okay, so that's Tuesday, the 28th, starting at 10.
Yes.
You got your,
I put it on my calendar.
all right, good. All right,
I'd like to address one last matter before we're done for today.
okay.
Is, I don't know that I will, but I believe, and I'm not studying it right now, there is some discovery potential in a protection order matter that's contemplated in the rules. I'm not saying I would do discovery or not, I just want the court to be aware of it. The one thing I'm particularly interested in is I would like to call as witnesses the two people that she cited in her ex parte hearing, her co-band member and Dawn from the Daughters of the American Revolution, who she, again, in that ex parte, those were the people she held out as the basis for her, I guess, mental distress or reputational damage in this. But I don't know who those people are. Obviously, despite false narratives about me, I'm just very good at tracking things, working things through. I believe those could be legitimate witnesses to be called. And so that's the only discovery thing I could think of. There could be some discovery things relating to any communications between her, Bob Finan, Copley, and the mayor.
Well, just send me a list. You're just basically...
There's specific rules about discovery and a protection.
But what you're just asking for the names and addresses of those two witnesses.
So they can be subpoenaed.
Well, just let me know.
Yeah, and there may be some, I need to think about, because I didn't anticipate this getting spread out another month. But in that interim, there could be some things like communications, and I can come to you, so I won't get accused of going to her.
If you send it to me, man, I'll get it to you.
Okay. And I can, by the way, I can do those requests without a formal discovery
You don't have
request.
to do that, you just email
Okay.
me, or you got my email? No, man, I don't know about this, but
Mr. Croswell, I met your assistant during the break.
Oh.
I told her I remembered you tried a case up in Dayton years ago.
Yes, sir.
With John Ryan.
Oh, my God. In federal court.
Yeah, was that where it was?
Yeah.
Yeah.
Yeah. That was, let me tell you, that was quite the trial. Yeah, I tried several up there. Yeah. I saw John the other day, and I was in New Orleans. Oh, thanks, man. I was in New Orleans at a seminar, actually, and he was there. I hadn't seen him in years.
Well, I think he's pretty much retired.
Yeah, I think so.
His son is active in practice. But if you shook hands with him, you'll notice he still has a pretty good grip.
Oh yeah, Johnny looked good.
Yeah.
I mean, he looked fit, and I know that when his wife passed away, it was kind of a tough deal.
That was tough.
Because she was young when that happened. But that's what I ought to do. Maybe I ought to get Ryan to come up here with me. What do you say? Would you bring him down here? He'd keep this thing stirred up.
Well, he might.
He might. Okay. Well, thank you, Judge.
Well, look, I want to thank
By the way, that card has both my regular number and the tip line, if you got any tips to report.
If I got any tips,
I'm getting a lot of them right now.
So you're going to get them, don't you worry. All right. Safe travels, Judge.
Well, thank you, and hey.
Great to see you.
Stay safe, both of you,
Oh,
and
we
Miss
will.
Little, of course, and have a good 4th weekend.
Yeah.
Recess. All right.
Off we go.
At ease, everyone.